and gentlemen. Thank you very much for attending this hearing on an issue of great importance to both public and private employees. I'm Assemblyman Joseph Lenthal, and I'm Chairman of the Governmental Employees Committee. Along with Assemblyman Barbaro, Chairman of the Labor Committee, we will be chairing this hearing this morning. And before we begin, I'd like to introduce the members of the panel. And I'll start on my left. Assemblyman Dennis Butler, who is a member of the Labor Committee. Assemblywoman Helene Weinstein, a member of the Governmental Employees Committee. Assemblyman John O'Neill, ranking minority member of the Assembly Governmental Employees Committee. Deborah Glick, a member of the Governmental Employees Committee. Sam Coleman, a member of the Governmental Employees Committee. And of course, Assemblyman Barbaro. And I'm sorry, I don't know. Why don't you introduce the people on the right?
John Christensen, Brother Bonasek.
Assemblyman Townsend. Dave Townsend.
And what's your name?
Assemblyman Bianchi. My personal hope is that this morning will generate ideas on how best to protect those employees who place their integrity above job security. Often their action benefit public safety and prevent consumer fraud. Unfortunately, their reward is often ridicule from peers and managers, and sometimes even termination of their jobs. Whistleblowers operate on the courage of their convictions in the face of potential retribution from their employers for simply doing their job as honestly as possible. Whistleblowing also promotes public safety and good government. We need to make it as easy as possible for employees to feel secure in their jobs while reporting imminent threats to public safety or violations of law. Obviously, the public is threatened when a responsible citizen may not report a danger to public safety because they may lose their jobs. Better protection of whistleblowers benefits the public as much as the employee. For public employees, their duty is especially clear. Upon entering office, all state workers take a pledge to defend the Constitution of the country and the state. As public servants, we ask their primary allegiance be not to an agency, but to the people they serve. Whistleblowers must be granted extraordinary protection because we ask them to uphold the laws of the state before any other personal consideration. To put them at risk of losing their job or facing a demotion is simply wrong. The people who follow their convictions do not deserve threats or reprisals, but our admiration. I certainly look forward to working with Assemblyman Barbaro and the members of the committees affected and the legislature to create a system in which the public and private employee will have no reason to compromise their respect for the law because they fear punishment from their employer. Assemblyman Barbaro?
Yeah, I want to thank Assemblyman Lenthal for taking the initiative to bring this hearing together. It's something which is desperately needed. A reading of the law as it exists for public employees and a reading of the law as it exists for private sector employees convinces me that it is not the kind of protection that we ought to provide for whistleblowers. I'm unmindful of the fact that the Court of Appeals, in dealing with a private sector whistleblower case, sort of threw the ball back to the legislature, and it was shortly thereafter that it appeared that many people in private industry agreed to have a whistleblower bill for private sector employees. What the commentary in McKinney's points out very shockingly to me, which I wasn't aware of, which I should have, is that there's no provision for punitive damages, so that an employer can, in fact, retaliate against a whistleblower and then is not faced with what I believe they should be, which is punitive damages, and they just have to pay back wages, compensatory damages. And also the problem that whistleblowers cannot get to the media and get protected. So as my colleague, Assemblyman Lentil, points out, there are holes in the whistleblower protection, and again, I want to compliment him for putting this hearing together so we can begin to examine that area.
Thank you. We'll begin this morning with our first witness, who will be first witnesses, Carol Knox and Jane Barker, Assistant Attorneys General from the Labor Bureau, the Attorney General's office. Good morning. Witness.
Jane Barker couldn't make it here today. She's the chief of our Labor Bureau. I'm Carol Knox, and I'm an Assistant Attorney General in our Legislative Bureau. And I'm happy to be here today on behalf of the Attorney General. Our comments are going to focus on the inadequacies of the current private sector whistleblower statute. 7 years ago, the legislature enacted New York's first statutory protection for whistleblowers. The bills, which amended the labor law and the civil service laws, were designed to provide a measure of protection to employees, both in the public and private sectors, who refuse to comply with their employer's instructions to violate the law, or who disclose to governmental authorities certain employer wrongdoing. As proclaimed by Governor Cuomo when he signed the bills, the legislation established a major right for employees, the right to speak out against dangerous or harmful employer practices. In our view, these amendments, while a good first step, were nevertheless quite narrow in scope. They limited the protection against retaliatory action that was afforded employees to a worker's reports of activity which constituted actual violations of law and which presented a substantial and specific danger to the public health and safety. In commenting on the 1984 bill when it was on the governor's desk, Attorney General Abrams expressed his concern that the bills were so narrow. He wrote that although the bills were good and gave some protection to employees, they did not clearly protect all whistleblowers. It was unclear whether the bill would provide a remedy for employees who refuse to engage in or who reveal illegal financial or accounting practices, such as filing false tax returns on an employer's behalf. If we are ever to make a dent in the widespread abuses known as white-collar crime, the Attorney General said, employees who disclose such illegal practices must be confident that they too will be protected. The Attorney General at that time in 1984 urged that this defect in the bill be cured by future legislation. Recognizing the limitations of the whistleblower statutes as enacted, the legislature in 1986 expanded the civil service whistleblower law so as to protect public sector workers who disclose information that they reasonably believe constitutes a violation of law or a danger to public health and safety. However, there was no similar enhancement of the original standard for the private sector workers covered under the labor law. In 1986, the Attorney General's comment to the governor when that bill was on the governor's desk was that unfortunately the protections afforded to public employees are still not granted to employees in the private sector. Thus, private sector whistleblowers are not protected from retaliation unless they can establish that the dangers they report in fact violate a law. Their reasonable belief that a violation has occurred is not sufficient, nor is there protection unless the violation of law constitutes a substantial danger to public health and safety. In our view, this is a double standard for private versus public sector employees. There's no statutory protection that prohibits retaliation by private employers against workers who report tax fraud, securities violations, fraudulent business practices, or other equally serious white-collar crimes, no matter how harmful the conduct may be. Nor does the law applicable to the private sector appear to protect employees who report violations of law that might affect only workers as opposed to the general public, even though violations of workers' rights might be very serious and harmful to the affected individuals. There can be no dispute that the reporting of white-collar crime and other violations of law serves a vital public interest. We have only to look at the savings and loan debacle or the recent criminal convictions related to trading in junk bonds to see how significant an impact such conduct can have on our economy and on those individuals who are the victims of white-collar crime. We know that employees are often the best source of information regarding illegal and unsafe practices. When workers are protected, the public is protected. A number of cases our office has brought over the years were based on information that we got from workers. They alone knew what was going on behind closed doors of companies. For example, employees of a Long Island chemical distributor told us that the company for which they worked was dumping hazardous waste on the plant site and along the roads outside the plant. We filed criminal charges against the owners, and 2 eventually went to jail. Similarly, a year later, a newspaper story based on an employee's allegations about illegal pollution at the Anheuser-Busch company near Syracuse led us to prosecute that company and for illegal water contamination. The brewery eventually agreed to pay a record $1 million in criminal fines and civil penalties. In another case that I think some of the committee members might be aware of, a former worker who had left the PIM thermometer company in Brooklyn because he got too sick at work told OSHA inspectors about a secret illegal operation in a basement room that the inspectors had repeatedly missed during inspections. In that room, that worker, along with his co-workers, was exposed to high levels of mercury, which was often dumped into the gutter. Because of the tip from that one worker who suffered permanent brain damage from mercury poisoning, the secret operation was exposed. Our office filed criminal charges against the company, and its 2 owners were found guilty of a crime. Currently, we have another major investigation underway stemming from information provided to us from an employee, and we doubt that we ever would have discovered that activity if the employee had not come forward. Workers should not have to risk losing their jobs or face retaliation when they speak out and disclose allegedly illegal activities. Their conduct often protects us, so we must do everything possible to protect them. Workers should not only be permitted to object to all illegal practices without reprisal, but they should be encouraged to bring such activities to the attention of governmental authorities without fear of retaliation. The current labor law provisions do not encourage disclosure and reporting of employer illegality, nor do they adequately protect those courageous and principled individuals who choose to stand up to wrongdoing in the workplace. Not one reported court decision has found that a private sector whistleblower has satisfied the stringent test established by the legislature for protection against retaliatory action. Yet, the facts in some of the decided cases demonstrate that the employer's conduct was plainly illegal and at odds with public policy. For example, in a case recently decided by the Court of Appeals that I believe Assemblyman Barbaro was referring to, a worker employed by a company under contract with the City of New York objected and refused to participate in her employer's fraudulent billing of the city. She was denied protection and lost her job, even though her objections, if true, would certainly have adversely affected the public. Had the worker been a city employee, she would have been protected for her whistleblowing conduct. In another appellate division case, a worker who discovered and objected to fiscal improprieties in a non-for-profit corporation established to help retarded children was not protected from being fired. In yet another appellate division decision, one that personally is shocking to me, protection was denied to an employee of an adult community residence whose employer discharged her after she disclosed to the district attorney's office her belief that a patient had been raped by another patient in the institution. The court in that case found that since the employee's belief that this had been a rape turned out not to be true, that it in fact was consensual activity, that employee was not protected and she was fired. Similarly, in another appellate division case, the Second Department held that a nurse whose employer allegedly fired her because she refused to disclose confidential medical records of another employee seen in the Employee Health Service, which disclosure may have been a breach of professional ethics and a violation of the education law, had no rights under labor law whistleblower protections. These courts have all been constrained by the labor law's requirement that the employer activity or conduct constitute a danger to public health and safety. When confronted with the unfairness of the statutory standard, the courts have referred the worker victims to you, the legislators. They have said that any additional protection must come from the legislature. The Attorney General strongly believes that the difference in treatment afforded private and public sector whistleblowers is insupportable. For that reason, our office will once again submit to the legislature a program bill to end this disparity. Last year's bill, Assembly number 7426, which was sponsored by Assemblyman Barbaro, was passed unanimously by the Assembly, as it has been in many previous years. While the Senate Labor Committee has reported the bill in previous years, it has never been reported by the Senate Rules Committee. Expanding the whistleblower protections in the private sector is at least as necessary as was the legislature's 1986 protection of the expansion of the rights of public sector workers. Given the nature and significance of the illegalities in the private sector, which have recently come to light, though these reasons are equally compelling outside of government. Moreover, unlike government employees, private sector workers enjoy no well-established internal procedures, such as inspectors general, through which to report illegal or dangerous activities of their employers. In addition, most public sector employees have statutory and due process protections that are not available to those who work in the private sector. Generally, they cannot be fired without cause. Thus, there is all the more reason to encourage and protect private sector whistleblowers. In sum, the expanded private sector protection proposed by the Attorney General in his program bill is consistent with the legislature's original intent in enacting the first whistleblower laws in 1984. To encourage employees to voice their concerns to their employers and governmental bodies without fear that their jobs will be adversely affected, and to encourage employers to police themselves and voluntarily correct situations where appropriate. I'm pleased to have the opportunity to appear before the committees on behalf of the Attorney General, and I'd be happy to answer any questions.
Thank you, Ms. Knox. I noticed that the Attorney General's bill, and especially from your testimony, talks about bringing the private sector law into accord with what we do in the public sector. I wondered if the Attorney General or you have come up with any suggestions for improvement of the civil service law, the public sector law as well.
Well, we've seen a number of proposals that will probably be discussed by other people testifying here today. I know that Dean Feerick had some good proposals when he was heading the Commission on Government Integrity. And I think that we're very supportive of a lot of the proposals to also strengthen the public sector whistleblower statute. Many people think it's unreasonable that an employee have to go report an activity to a supervisor before he can report it outside the agency, and I think that that proposal has a great deal of merit. We've been focusing on the private sector whistleblower statute just because the double standard is so glaring to us, and we think that if the legislature had to choose to do one thing to improve either one of these statutes, that's what the legislature should do. But I think both statutes could use a number of improvements.
Did you also, or have you also addressed the consideration that an employee must give their employer reasonable notice or reasonable amount of time rather to correct the problem?
Well, that's in the statute now. And our bill does not
really
try
touch
to
that.
loosen up that standard at all. And although I can understand where that requirement came from, that it's in many instances only fair to the employer to give them a chance to correct their conduct, in some cases it seems onerous to the employee to really expect them to go to their supervisor first. For example, in the PIM thermometer case that our office worked on for so long, I just can't quite imagine those workers going to a supervisor that was running this completely illicit operation in the basement to, tap the supervisor on the shoulder and say, I think this is illegal and we shouldn't be doing it anymore. I mean, there are just some cases when it doesn't make a great deal of sense, and I think maybe the legislature should consider loosening that requirement in some way. We don't have a proposal on that point, though.
I have a few more questions, but I'd like some of my colleagues, there are many of them here who'd like to ask questions. Assemblyman Barbaro?
I'm a bit confused. Are you saying that a court found that when someone reported a rape, that was not a violation of law?
That's what the court found. Yes, that is what
The
I'm saying.
court said that a rape is not a violation of law.
No, the court said that the employee thought that what she observed was a rape. It was a mental hygiene facility, and she came across 2 clients who were engaged in sexual intercourse, and she thought that it was a rape. It turned out not to be. It turned out to be that both parties consented, and so she turned out to be wrong, and the court found that she wasn't protected.
The reason why...
Actually, for both reasons, because it wasn't a danger to the public and because her belief wasn't correct. So people are expected to be legal experts as well as only expected to report with impunity public health, safety and health threats.
The reason why I asked the question is in reading the commentaries in McKinney's on the section of law that we're discussing.
That's why you're confused.
No, I'm not confused at all. I'm not confused at all. I'm trying to get you to say what I want you to say.
Okay.
The commentary makes the point that the worker was within the purview of the protection of the statute in the private sector if they reasonably believed that there was a violation of law, and then it turned out that there wasn't. Now, I'm saying that as I read the
I don't think the court said that in the case.
Now we're working together well now. So what you're really saying is that the courts are not following the clear intent of the law.
I think all the commentators, before these court decisions came down, all the commentators said that, of course, we will imply this reasonable belief standard. Then I think when the legislature changed the civil service law to put the reasonable belief language specifically in the statute, the courts might have started inferring from that the legislature could have gone back and specifically added that standard to the public sector, to the private sector statute if it had chosen to. So I don't think that the legislature necessarily meant to be so narrow.
Okay, so what you're saying is that the courts are philosophically regressively interpreting the statute.
I think they're not being as generous as they might, but I think they're being, somewhat true to the statutory language.
People don't want generosity, they want the law. So what you're saying, what I hear you saying, and I'm not saying that you're reaching my conclusion, but my conclusion is that the courts are working against whistleblowers and they're not enforcing the limited law that we have the way they should. Now, you have to appear before them. I don't have to, so if you don't want to respond, it's okay.
Well,
if they say that someone claims a rape and then reports it, and then it turns out that there wasn't a rape, that doesn't come within the purview of the statute, taking into consideration the commentaries in the McKinneys and the clear opinion of legal scholars, and the courts go the other way. Someone says if it looks like a duck, walks like a duck, and quacks like a duck, it's a duck. And so what you're saying is that it's desperately needed for us to clarify the
Yeah.
law, to force the judges to do what they're supposed to do.
Yes,
Okay.
that I am saying.
Another question, and then I'll reserve. In your opinion, should we be looking to the question of punitive damages rather than compensatory? Because under the best of circumstances, if I retaliate against a whistleblower, the worst that could happen to me is to pay them lost wages.
I'm sure punitive damages could help, but if you don't have a standard that protects the whistleblowers at all, which is where we are right now, it doesn't matter what kind of damages the worker can get. I mean, we just haven't seen any cases where workers have won under this statute, so
you're saying
we
on a-
don't know what kind of damages would
So you're saying on the
work.
pragmatic basis that the more urgent need is to establish the substantive basis of the
That's kind of a
protection.
threshold
Yeah.
first thing
Okay.
that we think needs to be done, and then a lot of these other things I think should be looked at too. I feel like I'm preaching to the converted here because the Assembly has passed the bill for a number of years.
Maybe the judges will listen.
I think the judges would listen if both houses passed the bill and the governor signed it.
Assemblyman O'Neill, and I'll ask everybody to please speak into their microphone so that...
Thank you, Mr. Knox. I just wondered, essentially with the new session and all, why in the resubmission of this bill have you not suggested or drafted a procedural change for that reporting function where the supervisor has to be solicited first by the person?
Just because we're trying to be as pragmatic and realistic as possible and just, wanted to get the standards to be at least somewhat protective for both public and private sector employees and then work on other things that both statutes need. I think that we would be perfectly happy to do that if that's something that the legislature wants to pursue this year.
I just wondered if you could not envision some procedure whereby that protection could be afforded, and yet the person who is intent on really using his conscience or her conscience to report something that is obviously, at least in that person's mind, a very illegal act, that there ought to be some sort of a clearinghouse first, and obviously the person being reported against should have a right to defend himself too. Certainly not trying to abrogate that part of the function, but I think it's a major step here that there is need for reform in the sense that when you go immediately to a supervisor, when one person has a complaint, it's something that's going to trigger an awful lot of opposition back to that person. That person is targeted right from the start, and I think there ought to be protection for that person from the start. And I would certainly encourage you to come forth with a remedy for that.
We'd be glad to look at that.
Thank you.
Anybody else? Are you, I'm sorry, Ms. Knox, the Ferret Commission has come out with a report regarding broadening of the whistleblower statute as far as public employees. Are you familiar with that at all?
Yes.
And has the Attorney General evaluated any of the recommendations by the Ferret Commission?
I think that we agreed with a number of the recommendations of the Ferret Commission. I think that his focus was more on improving the public sector statute, and as I've said, our focus for many years now has been to just as a first step, get the private sector statute up to the same level. But I think that a number of his proposals are based on things that his commission observed when they asked people to come testify. It's very difficult to expect either a public or a private employee to come testify, but when they're subpoenaed before a governmental body and not have that person have any job protection for what they say. I mean, I think some of his points were very good
Is the Attorney
ones.
General formulating any legislative proposals or recommendations based upon the Ferret Commission report? That
We're
was
not,
sent?
but I understand that there are others who are working on those, and we would endorse some of those proposals.
And
We're not presently working on anything.
would
No.
it not, if were you to support those recommendations, would that put you in a difficult, or the Attorney General in a difficult position, because you may have to wind up defending those public employers?
Well, the Attorney General is constantly in the position of defending public employers, defending all the state agencies, and I don't think he'd be particularly uncomfortable with having to do that. I mean, it's just kind of the State Counsel Division of the Attorney General's office does mostly just that, and I'm sure we'd be able to defend a state agency that had some good arguments that one of their employees wasn't protected, but I don't think that would change our view of that these statutes need strengthening on behalf of the employees.
Or you could recommend a settlement.
Sure, we do that a lot, actually. If we're really terribly uncomfortable with the position that a state agency has taken, we try to do everything we can to encourage them to settle, and I suppose ultimately it's even in our power to refuse to handle a case. We generally try to work it out, though.
Anybody else?
I just have one more question. I believe I read in the Attorney General's memo. I'm asking everybody to speak into the mic, and I forget to do it. I'm asking about the fact that reporting to the public sector, reporting to the news media, notifying the news media rather, as opposed to notifying an employer as a possible change in the law. I don't know if you discussed that in your testimony, but is that something that...
I didn't discuss it, but as a matter of fact, last year, and I believe the year before, the governor had a program bill that dealt with whistleblowing to the news media. I believe that his bill just dealt with the public sector, and as a matter of fact, the version of our bill that the Assembly passed last year incorporated the governor's proposal on whistleblowing to the media. So we're aware of that and think that would be an excellent thing for the legislature to pursue.
Thank you. Anybody else? John Bonasek.
I'd like to ask you a series of questions and assume I know nothing in this area. I'm the secretary to Mr. Milliken. I suspect he's involved in illegal activity, the private sector, with junk bonds. I call the SEC. I say, I think something's wrong here. Question one, can that secretary, she won't be suspended while there's, say, an investigation concerning Mr. Milliken? Is that true? Do they have suspensionatory powers while a complaint goes in and say there is an investigation?
Does a private sector...
I'm talking only of the private sector.
Sure. I mean,
Okay. So
in the private sector, the doctrine is generally employment at will, so the employer can do basically just about anything they want.
So what you're saying
They can
now,
fire her, they can suspend her.
okay, she can be shot out of the
him or
water
her.
right away.
Yes, except that I think that person may be protected under a federal statute that I haven't gotten into that does protect people who make reports to federal agencies. I'd have to look into that.
Now, let's take it a step further. That secretary now wants to be reinstated, and she's suing for lost wages. Is there anything to make her whole in addition to lost wages?
There's nothing under New York state law because that secretary would be out of luck. The standard that exists now doesn't cover that person.
So counsel fees could bankrupt regardless of the outcome of the proceeding?
Counsel fees alone, I'm sure if she had lost her job, would bankrupt her.
Okay, and my last question, from your experience in a whistleblower case in the private sector, from soup to nuts, how long does it take for adjudication at the first, say, at the Supreme Court level? Do you have any experience?
Our experience has been that they don't take that long because the courts dismiss them fairly quickly because the standard doesn't cover most of the employees who bring lawsuits. I don't know.
Okay, thank you very much.
It varies.
Anyone else? Mr. Townsend.
Ms. Knox, when these people, and again, I'm new to this, but my experience has been in law enforcement and conducting investigations, so I'd like to ask you a couple of questions along that line as your relationship to these people when they come forward. Is it my understanding that if they're going to divulge an illegal practice by their employer, they first have to go and divulge themselves to the employer that they're going to do this?
Yes, that's what the statute says. They have to report to the supervisor first.
And the reasoning behind that particular part of the statute?
Well, I wasn't I wasn't doing this kind of work in 1984, but I assume the reasoning is that in some cases, it's only fair for the employer to be on notice that the employee has observed an illegal practice, and often some employers will take that information and then correct the problem, and there won't be any need for the employee to go beyond the company.
Well, that doesn't make much sense to me, and I don't know who wrote the statute, but looking back into my career, when somebody came to me and told me that Joe Blow was selling narcotics on the street, and me being an undercover agent, he didn't go to Joe Blow first and say, I'm going to go to Dave Townsend and turn you in.
Right. I mean, I think it often does not make sense.
What we did in the law enforcement sector, when we had what we called an informant, not necessarily a whistleblower, but when we had an informant, we did everything in our power to protect the identity of that person. If it even came to making a plea bargaining agreement in the courts once an arrest had been made to protect the identity of that person. Granted, it could involve losing a job, but in some cases it could involve losing your life. I think something ought to be looked at in that respect to protect the identity of these people and to make them feel more free to come forward with problems along this line. My second question has to do with the collective bargaining agents for these employees as they negotiate contracts. Has any labor organization, any collective bargaining group attempted to negotiate into their collective bargaining agreement with the employer provisions that the person cannot be fired for bringing forth an illegal act? In other words, you have to have just cause in the private sector or in the public sector. Does that go across to the private sector also to discharge somebody? And because somebody comes forward with an illegal act on the part of the employer, is not, in my mind, as a former president of a union, police union, justify just cause to arbitrarily dismiss somebody.
Yeah, I'm not aware of any collective bargaining agreements that have that kind of clause, but that would be a very intelligent thing for unions to try to negotiate. And I could try to find out for you whether some unions have thought of this and asked for it. I'm not sure.
Thank you.
I might also point out to the gentleman, Mr. Townsend, that one of the recommendations of the Fury Commission that you may not have seen is to have a clearinghouse, an agency that acts as a clearinghouse to receive these complaints, so they can determine the legitimacy of the complaints and maybe conduct an investigation, so the person would not have to go to the employer. Sometimes, as you suggested, it's like the fox who guards the chicken coop. I understand what you're saying, and it may be something that we ought to look at in an effort to clear up that aspect of the law.
But is this another state agency over and above the Attorney General's office for these people to go to?
Not necessarily, but they might. The Fury Commission suggests designating an existing agency that already exists as sort of a clearinghouse agency.
At this point, they can go directly to the state Attorney General's office, though, if they have a problem?
There's no particular provision for that. It's just that people sometimes complain to our Labor Bureau, but these cases that I've talked about had nothing to do with our office. They're just, the statute gives people the ability to bring a private lawsuit.
But what I'm saying is that there are specific recommendations that we want to look at. This isn't legislation, it's recommended legislation that I would hope the Attorney General would look at and give us recommendations as to whether or not they endorse each and every one of these proposals.
Can I ask one question? Aren't we really avoiding the obvious, and that is unless and until we give whistleblowers the right to go to the media where they can get some protection, that they're still working within the system. And
there might be some dangers.
And so if you go to your supervisor may not be your friend. And because under the two statutes at best, what you can do is go to a supervisor. And then if the supervisor doesn't correct the problem, then you're still restricted to going within the hierarchical structure. So if
and
the
you may or
hierarchical...
may not have a responsive government agency to
That's right.
report
So
this
that
to.
to keep everybody honest, there has to be that alternative that if the whistleblower has followed the procedure mandated and the problem still exists, then they would be free to go to the press. Am I correct in that?
I think that would make sense, yes. I know the Assembly as a whole agrees, because that's the bill that was passed last year.
Thank you very much.
You're welcome.
Our next witness is Celia Viggo-Wexler, Legislative Director of New York State Common Cause.
Good morning. I'm fighting laryngitis, so if you have any trouble hearing me, let me know. I think that it's ironic the date you chose for this hearing. It's one day after the 5th anniversary of the Challenger disaster. We know in that situation there were whistleblowers within Morton Thiokol who tried to get their supervisors to listen to them. They were unsuccessful. Perhaps if they had gone public sooner, that tragedy could have been averted. Chairman Barbaro and Lentol and members of your respective committees, New York State Common Cause appreciates this opportunity to make clear Common Cause's continuing strong commitment to affording legislative protections to whistleblowers. Let me make clear at the outset that I'm not an attorney. I'm not really an expert on this legislation. The person who is our resident expert, Robert Newman, a member of our board and an attorney, could not come to Albany to testify today, but he did advise me on our testimony. If there are questions I can't answer, which is very possible, we will get you written replies from Mr. Newman. Common Cause was one of the main supporters of the current whistleblower law enacted in 1984. At the time the legislation passed, we hailed the law as an important first step in protecting whistleblowers, but we noted then, and we continue to believe, that the law does not go far enough. The circumstances under which employees are protected, we believe, are far too narrow. The current law, as amended in '86, protects public employees only when they report violations of law, rule, or regulation by employers, and private employees are protected only when the wrongdoing both violates the law and poses a substantial threat to public health and safety. We believe that employees in both the public and private sectors should also be encouraged to report a wider range of employer malfeasance: corruption, conflict of interest, waste, fraud, and gross mismanagement. We think expanding the definition of improper action to include waste, fraud, and gross mismanagement is especially welcome at a time when all levels of government are fighting huge deficits. We agree with U.S. Senator Carl Levin, the sponsor of the Federal Whistleblower Act of 1989, who called workers who pinpoint government waste the frontline soldiers in the battle to save taxpayers' money. Particularly in a time of war and recession, we know that money misspent in both the public and private sectors is truly money stolen from the taxpayer, shareholder, and the consumer. We also continue to believe that whistleblowers who are rebuffed by their supervisors when they try to report wrongdoing, or who receive no timely response to their concerns, should be able to take their cause to the news media without fear of employer reprisals. Employees who feel the public has a right to know about wrongdoing should not have to weigh the dictates of their consciences against the fear of sabotaging their careers. While it doesn't respond to all of our specific concerns, we do strongly support Assembly 7426. Chairman Barbaro and Attorney General Abrams are to be commended for this proposal, which would go a long way toward strengthening and improving the current law. We are also indebted to the State Commission on Government Integrity in its study, Brave Voices, report and recommendations on the need for better whistleblower protection, for pointing out other avenues for improving the law. Brave Voices noted that the current law's requirement that public employees first notify a supervisor before taking their concerns to a higher authority can be very problematic, especially when a worker has reason to believe that the supervisor is colluding in the wrongdoing. Clearly, when a public body convened to investigate possible wrongdoing in the public or private sector asks for information from employees, they should be free to provide it without fear of reprisal, even in situations when they had not complained to a supervisor first. Brave Voices also points out that the current law contains no notification provision. If employees are not aware of the circumstances under which the state's whistleblower law may be able to protect them, the law fails to provide either support or encouragement to those who are troubled by the wrongdoing they see, but fear for their jobs if they report it. Brave Voices goes a step further and recommends that a state agency be authorized to investigate any claims by whistleblowing public employees that they were victims of employer retaliation. Such protections are given to federal employees through the Federal Office of Special Counsel. We can certainly see the value of this recommendation. If a state office of Special Counsel could truly function independently, it would encourage public employees, knowing that they would not have to face the consequences alone to report wrongdoing. All the changes to the law which we have discussed may be opposed by employers in the public and private sectors who fear they would make it too easy for employees who are emotionally unstable or who hold a grudge against their supervisors to make trouble. We understand that concern, but your files and mine are not full of reports of government agencies and businesses whose operations and reputations have been savaged by freewheeling whistleblowers. We are all aware, however, of cases where courageous employees have spoken up only to lose their jobs or be placed in untenable work environments. More than worker rights is at stake here. If a whistleblower law does not provide enough protections to employees, the public loses a valuable ally in making sure that corporate and government officials obey the law and do nothing to jeopardize the health, safety, or financial well-being of the rest of us. Pitted against the enormous resources of a corporation or a government agency, any employee who wants to do the right thing will always be cast as a David facing Goliath. Workers need firm protections. Indeed, between 1984 and 1989, when the federal government strengthened its whistleblower law, not one federal employee won a ruling under the existing whistleblower statute, according to the Government Accountability Project, which is a Washington-based watchdog group. It is hard to imagine any whistleblower protection bill that could even the odds between the Davids and Goliaths of this world, but a strong law will at least ensure that the species whistleblower does not become extinct. Thanks very much for giving me this opportunity.
May I ask you also, Ms. Wexler, have you analyzed the FERC Commission proposals?
Yes.
I noticed that some of your testimony talks a great deal about some of those recommendations.
Yeah, we're very supportive of the report of the FERC Commission. We think that we would certainly not oppose any of the recommendations that they make. We think that, and we generally are very supportive of anything that would strengthen the current law and its protection to both public and private sector employees.
Any questions? Thank you very much. I might also say that we're happy to be joined by Assemblywoman Helen Marshall, who's a member of the Labor Committee. I'm sorry, I didn't see Audrey. And Audrey Pfeffer, who's a member of the Governmental Employees Committee. Our next witness is William Lindsay, International Brotherhood of Electrical Workers, Local 25.
That doesn't mean it's a dry subject.
I'll try some food.
Good morning, ladies and gentlemen. This man said my name is William Lindsay, and I'm actually here this morning wearing 3 hats. I'm a business representative with Local 25 of the International Brotherhood of Electrical Workers, which is located on Long Island. I represent construction electricians in Nassau and Suffolk County. I'm also a delegate to the Nassau-Suffolk Building Trades, and I'm here in Albany attending a statewide COSH meeting. I'm on the executive board of the New York Committee on Safety and Health. And on behalf of all 3 organizations, I'm here this morning to ask you to endorse certainly this concept of providing more protection for whistleblowers. What I'd like to do, though, is kind of confine my remarks and my expertise as far as the state prevailing rate statutes under the state labor law and how they're being violated every day and how this type of legislation will impact on the enforcement of that legislation. Over the last 12 years, I've probably filed more complaints than anybody on Long Island against unscrupulous employers who I believe were violating the state labor law as it pertains to the prevailing rate statutes. And from my experience, I can tell you that more than ever, the state prevailing wage laws are being violated. The reason for this is that the cheating is becoming more sophisticated. No longer are employers simply paying below the published rates. They now work longer hours, assign work to lower paid trades, or have workers switch classifications during the day. These types of violations are extremely hard to identify by the Labor Department investigators because most of the time the investigating consists of an audit of payroll records. It's extremely hard from written records to identify a worker who's working 8 hours for 7 hours pay, or to look at a job that should be done by, say, 4 electricians, which are much higher rate, that in fact is being done by 2 laborers and 2 electricians. The point is that more and more the enforcement of our prevailing wage statutes depends on workers cooperating with the Department of Labor. And the fact of the matter is that there is absolutely no protection for workers who cooperate with the department's investigation. What I'd like to do is just take a few minutes and share with you a real-life story that just happened last summer. We have had pending about 8 or 9 complaints against one employer on Long Island by the name of Mainline Electric. Besides the normal violations of not paying the posted rates and apprentice ratios, a standard practice of this employer is to work a longer day and to pay the employees for less. And his rationale for it is this is to make up for coffee breaks or any type of bodily functions that the employee might have to attend to during the day. This might sound pretty petty, maybe a half hour a day he steals from each employee, but when you're employing 30 or 40 people and you're continuously outbidding legitimate law-abiding contractors, it becomes significant. We became aware of this practice and informed the Labor Department. After investigating the allegations, the department determined that the only way to prove it would be to come up with an employee who would be willing to file a complaint and testify at a hearing. After talking to a number of employees, we finally found one who was willing to cooperate with the department. His name was Robert Watts. Bob was let go within days of the boss finding out that Bob was cooperating with the department. Of course, the reason that was given for Bob's termination had nothing to do with the cooperation of the department. But we really know the real reason why he was let go. We think this is wrong. A person should not have to lose his job simply because he cooperates with an official state investigation. Any legislation that could be enacted to correct this type of inequity would certainly be appreciated by the organizations I'm here this morning representing. And I think at the same time, I think it would do well in representing all the workers in the state of New York. Thank you.
Mr. O'Neill.
Thank you, Mr. Lindsay. I just wanted to ask you this question. I understand the problem that you're facing there, and I wondered if you felt that it might be possible that the Labor Department itself might be a better ally in checking on some of these problems if there weren't somewhat of a logjam caused also by the way prevailing wage is enforced. And in particular, I'm referring to this factor. There's no dollar cutoff for enforcement currently, or for enactment of prevailing wage in the where work is done for, say, a state or local government, or for a public benefit corporation or a not-for-profit. To wit, the replacement, let's say, of a door in an agency building, if it's a $50 job for repair or a $600 job for replacement of a steel door with casing, et cetera. Labor Department is currently spending a lot of time investigating such cases as those, I think, rather than putting the effort into the more serious transgressions of prevailing wage, the ones that you alluded to. Do you think that there's a problem in that the Labor Department does not seem to have adequate time or adequate enforcement for the very cases that you were suggesting?
I think that the prevailing rate statutes have a lot of room to be strengthened. I don't think by weakening them that will help the situation. My own experience, and I can only speak for Long Island, very little time is allotted by the department investigating very, very small jobs. They have so few inspectors that they allocate their manpower to much larger jobs. They don't do any spot investigations at all. They only go out on complaints at the moment.
Would you agree then that within an agency, let's take the dormitory authority out here at SUNY, and there is construction going on, and one of the workers is prepared to report the fact that the employer is violating the law in two ways. One, they're violating the law in not paying prevailing wage, but they're also violating the law in mismanagement, fraud, polluting the environment, that worker is at a terrible disadvantage.
Without a doubt. Without a doubt.
And that what you're really saying is that when it comes to public works under prevailing wage law, we transcend the detriment, the injury to the individual worker. It now impacts on the public.
Yes. Yes.
And that there is also a tremendous opportunity for fraud within the enforcement of 220 of the labor law, and that since the staff is woefully inadequate, that we desperately need this to have sort of citizen soldiers.
I agree. And an example of what you're talking about, Assemblyman Barbaro, just this past weekend, there was a contractor on Long Island that we have complained about on numerous occasions that predominantly does work for state agencies. It was a company by the name of C&L Electric. He has one willful violation against him now, and numerous other investigations pending. He presently has a contract for the Facilities Development Corporation. He was indicted late last week for fraud, I think about 7 counts of fraud in connection with these contracts with Facilities Development Corporation. So one, a lot of time does go hand in hand with the other. Not only is the individual rights of the worker being jeopardized by him speaking up, but a lot of time the public interest at large is being violated as well.
Thank you.
Yes.
Mr. Townsend.
Do you negotiate contracts for your electrical workers union?
Yes, I do.
Contract negotiations. Have you, in that capacity, ever attempted to negotiate a clause into your contracts with these people to protect your workers and a whistleblower?
Assemblyman Townsend, what you were talking about before, almost every contract that I've ever negotiated, there's always a just cause clause in the contract that if an employee is discharged, it's up to the employer through the grievance process to prove that that discharge was for just cause.
Correct, but my question is, have you attempted, or are you familiar with any other union that has attempted to negotiate into contract protection for a person that goes to a state agency, such as the Attorney General's office, to report a violation of ethics or whatever?
I'm not aware of any specific language in a contract that would deal with that, although I think it would be covered. I don't think the problem is with the organized section of our workforce, because almost every contract I've ever seen has some sort of grievance procedure that would, if an employee was discharged because he cooperated in a state investigation, I can't picture the arbitrator finding for the employer that was just cause for letting him or her go.
All right, so based on your expertise in this field, you feel that legislation enacted by the legislature of the state of New York for added protection with these people would provide better protection for them than a negotiated contract through the unions?
I think where protection is needed is for the unorganized sector of the workforce, most,
Unorganized.
Unorganized.
No union protection.
Right.
Thank you very much. Our next witness is Wayne Outen, Chairman of the National Employment Lawyers Association of New York.
Good morning.
Good morning.
I'm delighted to be here. There's so much to say in so little time. I'm going to try to race through my prepared remarks and hope to be of some help in answering questions. I'm here in a multitude of capacities. Number one, I'm here as the spokesman and chair of the National Employment Lawyers Association of New York. The National Employment Lawyers Association is an association made up of lawyers who represent individual employees as opposed to unions. We've got about 900 or 1,000 lawyers around the country. In New York, we've got 80 or 90 members who are practicing lawyers who represent individual employees. So that's my official capacity. Second, I'm an active litigator and representative of individual employees. I specialize in representing individual employees in the private sector. Third, I have personally worked actively in litigating some of the cases under this statute, including the Easterson case and the Remba case, which are two of the leading cases in this under the statute. Number three, an interesting historical footnote for myself is I was one of the 3 or 4 people who drafted the original whistleblower bill that was introduced into this assembly back in the early 80s. Tom Stoddard and myself and a couple other people sat down and tried to draft a model bill, which interestingly is basically what New Jersey ended up enacting and which this legislature did not enact. And third, another personal footnote is that I'm the lawyer who lost the Sabate case in the New York Court of Appeals about 3 years ago. And that's the case that put the final nail in the coffin of employment at will in the state of New York. So with all of those hats I'm wearing here, yes, sir.
Did you say that case ended employment at will in New York State?
No, I misspoke. It firmly established the dominance of the employment at will rule. If I said otherwise, I was mistaken. Employment at will is alive and well in New York, and New York has the distinction of being in the dark ages of employment law in this country as a result of the Murphy and Sabate cases and the absence of any statutory remedy to date, including specifically the whistleblower law. The whistleblower law has to be looked at in the context of the common law. I'm not going to spend a lot of time discussing it except to say that employment at will rule reigns supreme in the state of New York, and unless this legislature does something to provide some remedy for private employees, they have none. Absolutely none.
I think for the non-lawyers on the panel, would you just explain and elucidate on the employment at will?
I'd be happy to. The employment at will rule basically says that absent a contract for a term of employment, any employee in the private sector without a union can be fired any time for any reason, for no reason, or for bad reasons. That's the official statement of the law as it has been stated in the cases. That means that, of course, a person who's in a union has the benefit of collective bargaining agreement grievance procedures, and public sector employees have certain rights. But private sector employees who aren't in unions under the employment at will rule have no job security at all.
Other states do?
The employment at will rule was the rule across the country until about 15 years ago. Over the last 10 years especially, that rule has been substantially abrogated and diminished in most of the states in the country, with the principal example of California and Michigan, but even our neighboring states of New Jersey and Connecticut, by common law, have substantially narrowed the employment at will rule. And also statutorily have narrowed the rule as well. New York courts have categorically said in the Murphy and Sabate cases that the courts are not going to make any exceptions, no matter how extreme the circumstances, to the employment at will rule, and only the legislature will do it. Which is why the whistleblower law and other statutory provisions are so terribly important to employees in this state.
Can I ask you a question at this point? There was a time when the Court of Appeals judges in this state were elected in popular elections. And at that time, the Court of Appeals, when I went to law school, was regarded as one of the most progressive courts in the nation, sort of leaders in social progress and jurisprudence. And now we have appointed judges. In your experience, have you seen the Court of Appeals set off on a different tack other than the progressive tack that it took years ago?
Assemblyman Barbaro, I don't want to go beyond my knowledge and experience, and I don't have a terribly long history of litigating in the Court of Appeals. I do know that in the area of employment law, the Court of Appeals has gone off into an extreme tangent, contrary to any other state in the country. And whether that's part of a larger trend and what the causes are for that, I don't know. I lost the Sabate case 3 years and 10 months ago. I remember it vividly, and to this day, I cannot understand it. Why our Court of Appeals has taken the extraordinary and extreme approach they have taken, I don't know. I wish I did.
Was that a unanimous decision?
Yes, it was. And it was a whistleblower case, by the way. It was not under this statute because the facts arose before this statute. But even so, the facts of that case would not be covered by this whistleblower statute as it exists now. Now, the whistleblower statute, as I have alluded to, and I will say specifically now, is useless. In the course of this law, which has been about 5 years, no one, I repeat, no one has succeeded in even stating a claim under the statute. No one has gotten past a motion to dismiss. Someone asked how long it takes to litigate one of these cases. It takes about 3 months. You make your complaint and it gets dismissed. And if you go up on appeal, of course, it takes longer. And that illustrates how narrow and useless the law is. In fact, it's worse than useless, it's harmful. I wish the law had never been passed. It has caused the courts to even retrench further and say, the legislature has spoken, and look what they said. This is how narrow it is. It's like it's harmful in another way because it misleads the public and employees. It's like they say, here's a guard dog that's going to guard you. And you look off and you see the whistleblower statute and you think, I've got protection. If you don't know any better, you see a guard dog, you think you're protected. Then you get up and close and see the guard dog has no teeth, and then it's deaf, dumb, and blind too. I mean, it's misleading to someone who thinks they've got protection. And I hear it. I talk to dozens of employees every year, every month for that matter, some of whom are potential or actual whistleblowers. I tell them, assume you have no rights. You have none. And you know what? A lot of them don't blow the whistle because their job security is on the line. They have no protection. Now, I can go on and on with horror stories, but I don't need to tell you horror stories that you have no basis of. Just read the cases. The cases that have been mentioned here, the Easterson case, the Remba case, the Kern case, the Leibowitz case. All of those cases, the facts speak to the uselessness of this law as it exists right now. I know the Easterson case very well. I was hired to file an amicus brief on behalf of the American College of Occupational Medicine and a whole group of medical professionals, including the American Public Health Association, who couldn't believe that what happened in that case happened, and yet it was sustained all the way up the line.
Tell us what happened.
Easterson was the head, she was a nurse at the Long Island Jewish Hospital. She was the head of the Occupational Health Service, which is the in-house facility for providing health services for employees of the hospital. And they had all kinds of codes and procedures and manuals for the hospital which said that employee medical records are confidential and cannot be disclosed without the employee's consent to anyone else in the hospital, particularly including the line managers who supervise the employees. Also, the canons of ethics that govern the nursing profession provide the same thing, as does New York law, the education law. Ms. Easterson was commanded, as head of that department, to turn over a particular employee's medical record. And she said, no, I can't. The policies say I can't. She was fired, specifically and unequivocally in retaliation for that. And that's not just an allegation. That's an admitted fact. This is not allegations in a motion to dismiss that may or may not be true and maybe some overreaching employee. These are admitted facts. That's the reason she was fired, because she refused to turn over that employee's confidential medical record. She brought a lawsuit. She tried to negotiate, of course. She brought a lawsuit, and it was dismissed in the Supreme Court. It was appealed to the Second Department. It was dismissed in the Second Department. And the decisions are public record. I have them right here. I filed an amicus brief in the case. The court found that, yes, what they ordered her to do was illegal. It violated the New York education law, but it didn't create and present a substantial and specific danger to public health and safety, and therefore she had no claim under the statute. And incidentally, it did create a substantial and specific danger to public health and safety, because one of the reasons for confidentiality of employee medical records is to make sure that employees who are coming back to work in the hospital are going to disclose openly and candidly any sicknesses or injuries that they may have before they come back to work. And if they may endanger the patients in the hospital, then they'll be told not to go back to work. That was all laid out fully in the record in the Supreme Court of Queens County. The court found still no danger to public health and safety. So this is an example of Assemblyman Barbaro. You talk about the hostility of the courts. The courts are hostile to employee claims. I will state it unequivocally. Maybe the Attorney General's office is reluctant to do so. The courts are hostile to employee claims across the board, under this statute and otherwise. And I can speak from personal experience over many years on that.
So you're saying that the private sector statute, as weak as the public sector statute, it's even worse?
Oh, far, Your Honor.
Because the public sector statute doesn't say and, it says or.
That's one difference. I have a whole list of changes that should be made to this law, some of which are essential and some of which are desirable. One of which that is essential is to eliminate that and make it an or. It should be enough if it's a violation of law, rule, or regulation, or creates a danger to demonstrates a danger to public health or safety. There are a lot of others. That creates and presents a substantial and specific danger to public health and safety. That's very narrow. Nobody has succeeded in fitting that definition to date. No one. Substantial and specific. And public health and safety. They would take the Kern case, which was alluded to before by the lady from the Attorney General's office. I have the decision right here. She stated the facts correctly. The judge found that the allegation was that there had been a rape. And the fact is that it turned out, apparently, that it was a consensual sexual act, and therefore there was not an actual rape, and therefore there was not an actual crime, and therefore there was no violation of the statute, because it's not enough to have a reasonable belief that the law is being violated. You have to be right. After all the facts are in, after all the law has been examined, the employee who blows the whistle has to be proved to be right. Not even enough if they have excellent cause or good cause or reasonable belief. They have to be absolutely right. That's a ridiculously narrow provision. The law doesn't, by the way, the statute doesn't specifically say that. The statute is a little bit ambiguous on that, as the commentary points out. However, that is the way the courts have read it. That's the way it was read in the Kern case. You have to be actually right. I think it's a wrong reading, but it illustrates the hostility of the courts.
Are your recommendations based upon the New Jersey statute that you spoke of?
I commend to you the New Jersey statute in a number of regards. For example, on the question, I have it right here, on the question of what is the standard, it provides, if it's a violation of law, rule, or regulation, is if it's a fraudulent or criminal act, or, this is a better statement, or is incompatible with a clear mandate of public policy concerning public health or public safety or welfare. That's a far better statement of the standard for what is being disclosed. Moreover, I think that even if you change the so-called and here to an or, where it's a violation of law, rule, or regulation, or a danger to public health or safety, I think there should be another one, which is a violation of public policy, or a clear mandate of public policy. I think that there should be, there are many examples that may not be technically a crime.
What about corruption, waste, or
Exactly.
mismanagement?
Well, once you get in the private sector, you can't go too far down that road, because because it's private employer's prerogative to be wasteful and have mismanagement if they wish to. The public doesn't have, I think, an interest that goes that far here. But I think that where the public interest does impact is where there's a violation of law, where there's a danger to public health or safety, or there's a violation of some other clear public policy that's not founded in either a danger to public health and safety or a statute. And that's what I would commend to you. There are quite a number, I don't want to run over my time, but there are quite a number of other suggestions that I have. May I have 2 or 3 more minutes?
Sure.
Okay. There is the provision in paragraph 3 on application of the law, which says, and this was alluded to before, that you have to afford the employer an opportunity, you have to give notice to the employer that you're going to do this and afford the employer an opportunity to correct the problem. I know where that came from. I was on this committee that drafted the bill 10 years ago. But there were a whole bunch of exceptions to that. What the legislature did was take the general statement and knock out all the exceptions. Let me tell you what the exceptions were, and they're very reasonable and apparent ones. One exception should be where the employee reasonably believes that the employer is already aware of the activity, policy, or practice that's involved. Obviously, there's no need to go and throw yourself at the mercy of the employer when you know that they already know about it. The PIM thermometer cases that was mentioned earlier is a perfect example of that. Number 2, if there's a serious or imminent danger, obviously, why should you have to wait to go notify somebody in the company if there's some danger to the public or to the employee or to co-workers, that if you wait, there's going to be someone hurt? Or if there's a danger to the employee himself. We're all familiar, unfortunately, with the situations where it may be that there's actual physical danger to the employee, that they may suddenly be hurt if it's found out that they're a whistleblower. And they shouldn't be put at jeopardy in that. Bad enough to be put in jeopardy of being ostracized and losing their job, but to be put in physical danger for their life. So our view, when we drafted this thing 10 years ago, was that in trying to be reasonable about this, except in certain circumstances, an employee should try to work it out inside, in the company. See if the employer, given a due opportunity to do so, will solve the problem. And maybe they will. Maybe they don't know about this problem over here at this plant or with this in particular supervisor. And there was a balancing that went into that. I'd be perfectly happy if that provision were struck out myself, but it was an attempt to be reasonable. But what happened was, when it was passed, the hard rule was left and the exceptions were taken out. Now, there's been some comment about the remedy provisions, which is paragraph 5. As Assemblyman Barbaro correctly pointed out, it doesn't anywhere begin to make anybody whole. I mean, as if it mattered at this point, because nobody has ever gotten to that point. Nobody has ever even gotten to trial, to say nothing of getting any relief. But maybe if somebody does ever, if you change the law, get there, you've got to have some adequate remedy for the employee. These things are extremely stressful and de-stressful for employees. You can imagine, and I can tell you, about how much stress, emotionally and otherwise, people go through in making the decision to blow the whistle and then suffering the consequences. Either they get fired, or if they're on the job, they're ostracized and ridiculed and so forth. There's a great deal of emotional distress. Plainly, there should be a provision here allowing for emotional distress recovery for employees who have the gumption to stand up and blow the whistle. Second is, I think that in those situations where the employer has acted intentionally or maliciously, there should be provision for punitive damages. I don't think there should be punitive damages in the run-of-the-mill case. I wouldn't go that far. But where there has been willful or intentional violation by the employer or retaliation by the employer, there must be punitive damages. Otherwise, what is the punishment to the employer? All they have to do is pay the wages for the person that they would have paid if they hadn't violated the law and retaliated? I mean, where's the disincentive? Where's the sting?
Okay, so what damages do you assess? Do you create a cause of action for stress?
Not a cause of action, a remedy. Within the remedy, the cause of action would be for retaliatory discharge or other retaliatory actions, by the way, besides discharge. It can be demotion, sending to Siberia, what have you. But there should be damages for emotional distress in addition to lost wages and counsel fees and
Well, it's been a long time since I drafted a negligence complaint, but let's not go into that. What you're saying is that that an employee should be allowed to recover compensatory damages and damages for emotional stress or other resultants from the discharge.
Well, the term of art, compensatory damages, encompasses emotional distress damages.
It does?
Yes.
I mean,
if the law were to say here that under paragraph D, compensation for lost wages, benefits, or other remuneration, if it were also say compensatory damages or emotional distress, it would either way it would cover emotional distress damages.
Okay. So, but we want to
Yes.
indicate it. That's my point.
Yes,
Okay.
exactly. And again, punitive damages for intentional or willful violation of this law, I think, is essential to provide some teeth to this for the egregious violators. A couple of more quick points, if I may. Paragraph 7 is one of the most bizarre provisions I've ever seen in a law. It provides that, it says nothing in this section shall diminish the rights, privileges, or remedies under any of the law, rule, or regulation. Fine, that's fine. But then the second part of the sentence says the following: except that the institution of an action in accordance with this section shall be deemed a waiver of the rights and remedies available under any other contract, collective bargaining agreement, law, rule, or regulation, or under the common law. That means if you assert your rights under this statute by bringing a lawsuit, and there's a case that has specifically enforced this, you waive any other claims you may have. Discrimination on the basis of race, sex, age, national origin, you waive those claims. You have a contract claim, an individual employment contract, or a collective bargaining agreement, you waive those claims if you assert the rights under the statute. That's silly. I've never seen such a thing. I don't know where it came from. The rights under this law should be cumulative. They should be in addition to whatever rights you may have under contract or collective bargaining agreement or the common law or any other statute, such as the human rights law. And finally, and it was mentioned earlier, there should be notice to employees of the rights under this law. I think this is one of those statutes that should be added to the notice requirements of employers, posting and so forth, that employees be aware that they have the protections of this law. And one final point, there's been mention of a special counsel and so forth. I think that would be wonderful, but in view of the budgetary crisis in the state, as wonderful as that would be, I fear that adding something like that, which would add even incrementally to the state budget problems, may limit even more than otherwise the chances of this bill passing the Senate.
But what about just a clearinghouse agency that already is in existence?
If it had no budgetary impact, I think it would be a wonderful thing, because this really is an area where it's a David and Goliath situation.
Well, we already have an inspector general in the state.
If the inspector general were empowered to process these claims at no cost to the employees, it would be a great benefit to employees who really generally don't have the money to go out and try to find a lawyer like myself or others who would try to handle a case like this.
Have you submitted
Have
you submitted your recommendations to our offices of either Assemblyman Barber or myself?
I have not. I will be glad to.
I think that would be
do so.
Appropriate. I'd like to take a closer look at those recommendations.
I think, in effect, you're saying we made a mistake when we enacted the statute and we should have held out for more.
Absolutely.
So that when we were told the Senate won't go along, and we ought to said, okay, we'll see you another day.
I would have preferred if the law had not been enacted in the first place, frankly, for private sector employees. It's done more harm than good in the last 5 years.
How about the public sector? You satisfied?
Well, the public sector was amended in '86, so at least has some teeth. Before that, it was useless also. It could use improvement too, in a multitude of ways, including some of the ones I mentioned. And there's one sort of minor procedural one that I'm litigating at this very moment. I have an argument next Tuesday morning in Supreme Court in New York County over an ambiguity in the public sector law, Section 75B, which says that an employee who's subject to a collective bargaining agreement where there's an arbitration procedure may elect to assert their rights under the public sector whistleblower law in the arbitration. The Attorney General's office is taking the position that that means the employee must bring it in arbitration or not at all, that they have no right to go to court. And I'm arguing that the employee has an election of forums. The employee may go to arbitration or may not to go to arbitration, but instead go to court. And that's an issue that is before the courts at this very moment on that particular provision. And if the legislature would clarify that, I believe the employee should have the election of forums to either go to arbitration or to court if they would choose to go to court instead. And so far, incidentally, there was a decision issued about 4 weeks ago on the same issue by Justice Shaineswit in the New York County, holding against my position and in favor of the Attorney General's position in a similar case, providing that the employee must bring the claim in arbitration or not at all and cannot go to court. Any other questions?
Thank you very much.
Yeah, thank you.
Our next witness is Barbara Zarin, President of the Office of Management and Confidential Employees.
Good morning. I'm not a lawyer, so I won't take as long to present my remarks. I am Barbara Zarin. I'm president of the Organization of New York State Management Confidential Employees, which is otherwise known as OMSE. We represent the interests of the 14,000 managerial and confidential employees of the state, most of whom obtain their positions through competitive means. On behalf of those employees, we do the following kinds of things. We advocate for changes in legislation, such as whistleblower legislation. We enforce employees' rights in the courts wherever adverse personnel actions occur, such as disciplinary actions, job abolitions, unwanted transfers, etc. We protect the constitutionally mandated merit system through appearances before the Civil Service Commission, defend members at disciplinary hearings conducted in accordance with civil service law, and represent members before the Grievance Appeals Board in accordance with Executive Order 42. Our goal in this regard is very simply stated, to ensure that New Yorkers who pay our salaries and benefits, and this includes we public employees as well, receive the best services possible, free from corruption, favoritism, and pettiness by highly motivated professionals who operate in a safe and healthy environment. We represent management confidential employees in a broad spectrum of jobs, including positions like attorneys, secretaries, program managers, and division directors in most agencies, personnel, budget, and fiscal staff, staff at the Civil Service Department who run the merit system, affirmative action officers, chiefs of service, treatment team leaders, on and on and on. Our members are in positions where they can easily observe wrongdoing. Just for some examples, both personnel staff and Civil Service Department staff would certainly be aware of occurrences where the civil service rules are being circumvented. Business offices in facilities would know whether acquisition of supplies, equipment, food, etc. is taking place in accordance with the rules. Systems and electronic data processing staff would know whether contracts for these services are necessary, cost-effective, or wasteful. Clinical staff, such as treatment team leaders, chiefs of service, directors of the various disciplines, can clearly point out whether treatment plans are developed, implemented, and carried out in the patient's best interest, or on occasion, whether they serve other, possibly more politically expedient purposes. We have supported your efforts both in 1984 and in 1986 to enact and amend what is now known as the whistleblower law. We have also lobbied for additional amendments to strengthen the law by including, with good faith cautions, information given to the media. As we all know, these efforts have not succeeded. The time has come, we believe, to enact legislation to protect whistleblowers when they report to the media, in good faith, their belief that a law, rule, or regulation has been violated. This would obviously go beyond the health and safety issue. The reasons are obvious. First of all, Governor Cuomo has, in his State of the State message, once again urged support for this legislation. Second, as most of you probably saw, the New York Times recently reported on a study which showed that the average whistleblower in the federal service is a 47-year-old family person employed 7 years prior to exposing wrongdoing. In that study, 51% of the whistleblowers reported that they are no longer with the same agency. 1 out of 5 reported that they were without a job, while 25% mentioned increased financial burdens on the family as the most negative result of their reaction. In those instances where individuals were not transferred or lost their positions, 82% said they were harassed by their superiors. This included reduced responsibilities, close monitoring of their duties and telephone calls, and poor performance evaluations. In effect, these individuals with the courage to come forth suffer effects not only on themselves, but also on their children and their family life. Often it is the most frightening thing they have ever done, and rather than being praised and rewarded, they are persecuted. The first bill that President Bush signed into law strengthened protection for federal workers who reported government wrongdoing. The President noted that a public employee who reports wrongdoing is a public servant of the highest order, and added that such people should not be fined or rebuked or suffer financially for their honest and good judgment. We agree with that. On behalf of a career management confidential employee, we recently settled a long-term and costly lawsuit. This person was considered a whistleblower. We believe that not only should the proposed legislation expand the rights of public employees to report violations to the media, but it should also include a private right of action for them in instances of retaliation. And we too would support expanding the legislation to cover waste, fraud, corruption, conflict of interest, and those other kinds of issues. In many cases, as has been previously pointed out, the person or persons who the whistleblower believes is participating in improper or illegal activity is that employee's superior or superiors. There are no valid arguments not to do this legislation. It is the right thing to do. Last, probably most important from our perspective, despite the existing statutory protections, most employees are still afraid to come forward and report on wrongdoing, corruption, favoritism, etc., because of the subtle and not so subtle retaliation that is most surely visited upon them. Many believe, however, that the media will expose wrongdoing that might otherwise not come to light. Thank you very much for your time. We look forward to working with you to ensure that this legislation we're advocating becomes law. If you have any questions, I will be happy to answer.
Ms. Zarin, how do you think that managerial service could be improved by us beefing up the whistleblower law and in terms of waste and mismanagement in government?
We have many members who over the years have come to us and indicated that they are aware of situations which they believe are wrong, are wasteful, and we always discuss whether or not they want to come forward and report that. In most instances, they have not been willing to do so because despite the protection that the law theoretically gives, there are many, many ways that they feel the effects of coming forward. Despite the Inspector General's office, despite the internal Inspector Generals, despite any facility that the Attorney General may have for dealing with this, people simply are afraid to expose themselves. Retaliation doesn't come only in the form of a layoff. There are a lot of other ways that people are harmed if they come forward. The managerial people are in many cases better positioned to know about the kinds of things that ought to be reported. In some instances, they have to be involved in them, unfortunately. I guess I'm not answering your question.
No, you are. I'm just...
Okay. We believe that and it has been pointed out earlier this morning, going to your superior or going to the agency hierarchy will not always cause the issue to be adequately addressed. There needs to be another mechanism. The media, because of their confidentiality of their sources, is believed by many people to be a viable route for exposing the kinds of things that people are concerned about.
I guess what I really want to know, in addition to what you've already said, is how you think this will this really improve government service? I mean, do you see this as something that will markedly improve what goes on in the managerial aspect of government?
It will improve government service if people take the need to bring these things to light and to act on them expeditiously, if they take that seriously, and that people are not punished for coming forward.
Okay. Thank you, Barbara.
Thank you.
Next witness Next witnesses are, I believe, Kenneth Joyce and Rosemary Bailey, Executive Director of New York State Law Revision Commission and Associate Attorney of the New York State Law Revision Commission, respectively.
Thank you. It's Rosemary Bailey. Just a couple of caveats at the outset. First, we've just become recently aware of this hearing, so we've not really had a chance to prepare as well as we would have wanted to. Secondly, the New York State Law Revision Commission has not, as a commission, come to conclusions with respect to the many issues that are before this body and which have been talked about this morning. In January 1989, we sponsored a all-day conference at the Fordham Law School on the whistleblowing in the public sector, and this was held in conjunction with the Crowley Institute of Labor and Employment at Fordham University, and we had speaking at that conference Joe Bress, who was then the Executive Director of the New York State Ethics Commission and was recently appointed Director of the Governor's Office of Employee Relations, representing also Elizabeth Moore, who was at that point the head of the Government Office of Employee Relations and was now because as you know, the Governor's Council. We had John Feerick, who is the Dean of the Fordham University and of course the Chairman of the New York State Commission on Integrity, who's authored the report referred to this morning several times. Kevin Frawley, who was at that point the Commissioner of Investigation of New York City. Ruth Messenger, the Manhattan Borough President, and Sam Roberts, the Urban Affairs columnist for the New York Times. We had a second conference in the fall of 1989, again in conjunction with the Crowley Institute, going into the private sector, in which again Mr. Bress and Dean Feerick appeared and took part. Richard Givens, a private attorney and head of the New York State Bar Association Task Force on Simplification of the Law, took part. Two professors from Fordham University, one Jacqueline Nolan Haley, who spoke on an alternative dispute resolution, Bruce McClanahan, also a professor of law, and Mr. Outen, who just spoke previously here. The Fordham University Urban Law Review, the Urban Law Journal, is going to have a symposium on both private and public sector issues and will report on, among other things, those conferences that I just spoke to, and that my understanding is that symposium will be published in the next couple of months. What the Commission has done, the Commission staff, headed by Rosemary, at this point is really attempted to analyze and focus on the distinctions between the private sector bill and a private sector statute and the public sector statute. Many of those differences have been adverted to already, and I don't want to take up the committee's time. I do think, though, that I'd like to run through them and indicate some of them have not, I don't think, been spoken to specifically, and focus on perhaps those, but also give the committee at least some idea of the staff's view from these conferences of perhaps a spectrum of toughness to easiness on legislative calls. I think that one of the things I would like to reiterate, and has been said here several times, is that given the approach of the New York Court of Appeals on this issue, and on the issue of employment at will generally, what you see is what you're going to get. The legislature really is speaking here on its own. It cannot really expect that the ball will be carried any further than it's carried by the legislature, by the Court of Appeals. The court has clearly taken the position that these are delicate public policy judgments that should be made by the representatives of the people and not by the court. That's all. That's not, of course, the view that some other courts have taken, especially the California courts, but that is, I think, clearly the view, and I think it puts a special type of burden on the legislature, and viewing this legislation is somewhat different than others. We, for example, have been dealing, just as an example, we've been dealing with an issue called the mitigation of damages by landlords with respect to tenants who do not pay and are evicted, etc. With that legislation, we can look and see the courts have been moving in a certain direction, and perhaps we can help them and maybe get ahead of them. You can't do that in this area. This area, the courts are at a standstill. And so that it's important, because whatever you say, I think it's already been adverted to, is going to have positive as well as negative implications. So it's very, very important to view legislation in that regard. With that as a background, excuse me, did you have a question?
Yeah.
Yes.
I'm sorry if I appeared to interrupt you, which I was
No, that's
doing.
all right. I'm sorry.
We've had testimony that the courts, and in my opinion, I agree, the Court of Appeals is playing a terribly regressive role. That's my opinion. Maybe some others are not willing to go that far, but they're clearly not following the intent of the legislature, limited as it is in this legislation. Would you agree then that you can play a very positive role in speaking out for the need to clarify, tighten up the law as it exists today? In other words, you're giving a message to the legislature, but you're really also giving it to the Court of Appeals, because I'm very concerned over the fact that the Court of Appeals is coming out with an overwhelming majority of unanimous decisions. It's almost as if there's a mind control process going on there.
Well, I think
I'm not asking you to agree to that.
No.
But I'm very concerned, and it's almost as if we need an intellectual bomb to break up what's going on over there.
Well, I think you have to distinguish between the decisions of the Court of Appeals where there is no legislation, such as in where the legislation clearly does not reach, such as some of those cases that Mr. Outen has spoken to, where they have taken the view that the legislature is the only body that's going to decide this case. We're going to stay at a standstill. Of course, they're deciding it, obviously. They're deciding it against the employee, but they're not going any further than the law as they see it at the present time. You have to distinguish between those cases where I think you can clearly say the Court of Appeals, the leader here, has said no. But with those cases where there have been interpretations, for example, of the present statute as to whether or not public safety and health is involved. And I don't think you can really lay things at the Court of Appeals for those. I think you have at just this point you have lower court decisions, some of which I think are niggardly in their approach towards these things. And I think to some extent, however, that's because the legislation and the legislative history of this clearly represented compromises which those courts can go and look at for their decisions. So I really think if I were to give the lower courts a grade on this, I think they'd probably get a B. I don't think that they're going contrary contrary to what they view responsibly as legislative purpose here. I think that they have the signals here have to be clear, and they certainly have to be in certain areas with respect to the Court of Appeals. They have to break ground that has not been broken thus far if you want the courts to do anything. If I could just try to move to some of those areas. As I said, I don't want to take up the committee's time with those that have been gone over, but...
Can I just interrupt for just a second? I know you have more to say, but I want to follow up on what you said.
Yes.
And is it then your opinion that the lower courts are following the lead of the Court of Appeals and not anxious to break new ground, even if the situation might arise that would call for it?
Well, in the areas where the statute does not impact, they have no choice, obviously, except to follow what the Court of Appeals has said, and the Court of Appeals have been very adamant in that area. With respect to the where the statute arguably impacts, I think that perhaps they're taking a cue from the Court of Appeals decisions in the areas where it does not impact, and perhaps saying that the whole area is one where we are going to say the legislature has to move forward. I don't think you can fairly accuse them of doing that without having an argument on the other side. Excuse me?
What Mr. Alton said was that in the case he had where he represented the nurse, that the Court of Appeals outrageously, and he underlined the word outrageously, denied the fact that this nurse should have been protected because the threat to the public safety was implicit in the confidentiality provision of the law, which was intended to protect the public, so that if I'm sick, I would feel free to, to disclose this, and I would be protected. So he would give them an F, in the sense that not only are they following the law, but what they're doing is strictly interpreting the statute, which is very regressive. And I know you have a lot to say, but it just seems to me that you're in a unique position to make that statement.
Right.
Because I got to tell you, when this legislation came before me, I did not want to move it.
Right.
And I was accused of being an obstructionist, being a radical, being a bomb thrower, a loose cannon. And I took the position at that time, why should we pass a bill that's going to not do the job and diffuse that social movement? So we're trying to regenerate that movement now. And I would be very anxious to get a very clear,
right.
If I can just finish this point.
Sure, excuse me.
I would suggest that, and I know you are, those that are committed to correcting this egregious situation, to get clear, forceful statements from you folks on the need for this remedial legislation. You don't have to criticize the Court of Appeals, but I think that this cries out, for clear, unambiguous, forceful statements by people, because I'm personally embarrassed by the fact that a Judge Cardozo can write the nature of the judicial process. Court of Appeals was the shining light, and now it's at best a candle.
I guess I would just respond by saying that if you look at the language of 740, the way it exists now, and it talks in terms of a substantial and specific danger to the public health or safety, that's not the kind of legislative language which incites a court to come down with liberal interpretations protecting employees. And especially given the legislative history of this. So although I maybe, perhaps we would disagree on the grades, I think that clearly that language is restrictive. And I think it's up to the legislature to make that decision. Now, that is an area which I think is what I would call a middling type of decision, as opposed to a really tough decision or an easy decision. I think, for example, a tough decision would be whether both of the laws, which require that there be a violation of some law, rule, or regulation, as opposed to getting into things like corruption, mismanagement, ethics, things some of which the the FIRA Commission has suggested. I think that's a really tough call because once you move off of violations of rules, regulations, or statutes into things like mismanagement, especially if you're in, as Mr. Outen mentioned, if you're in the private area, you get into more ambiguity and therefore more room, as employers would say, for pretextual claims on the behalf of employees. I think the middle ground, the one that you referred to, Mr. Chairman, a middle type of decision is this one of moving off of this restrictive language of substantial specific danger to the public health and safety. That is not in the public sector law. It's only in the private sector law. If you're going to move off of that, perhaps there should be some thought that if the private sector demands different considerations, perhaps it should be movement into the type of language that Mr. Outen referred to. Perhaps we should think not just in terms of any violation of any rule, regulation of law, which is what the public sector has, but perhaps some rule or regulation that constitutes a criminal law or felony, a misdemeanor, as opposed to some violation of any administrative law. One of the people at that conference in this area said, you know, when you talk about the public sector statute, which involves any rule, regulation, or law, that there are thousands of violations which are minimal and people would not want if they're asked, do you want to protect an employee? One might respond, well, no employee is going to blow the whistle on that, and the response to that is, sure they will if they want to protect their job. So I think there's a balancing act here that has to be done, and I think you do have precedent in some of the statutes that have been cited to you. I would say that I think one of the easy questions here, which clearly should be amended, is the one which the Rember case represents. Ms. Knox referred to that earlier in her testimony, where she said if the employee in that case had been an employee of the City of New York rather than an employee of an independent contractor of the City of New York, there would be protection. And there's no reason whatsoever to make that distinction here between an independent contractor of a government and an employee of a government. They were both both were paid by public funds. They should have protection. There's a Florida statute recently, 1986. Was it 86 or 88? That specifically provides for coverage of independent employees of independent contractors, and in effect makes them public employees rather than private employees. I think you could even go further than that and get into employees that are companies that have some sort of public funding. But aside from that, I think where you have this distinction between employee and independent contractor is an easy legislative call and should be made a change in this bill. If we move to the types of activities that are protected, both statutes, both the public and the private, require or protect a disclosure of the violation to a public body. But when you get into other activities, you find that, ironically, certain activities of the private employees are protected, which are not protected in the public area. For example, 740 protects a private employee from providing information, even though that does not amount to a disclosure of a violation. For example, to a legislative body such as this, whereas in the public employment sector, the public employee is not protected. I would not be protected if I provided you with information which would lead to your determining that there's been a violation of some rule or regulation by an employee, because under the statute it's not protected. There are some who argue that the public employment statute could be construed to protect that as a disclosure, but that would, I think, at least be arguably a strained interpretation, and there's no reason why it shouldn't be clarified. Another protection that's given to private employees that's not given to public employees is one of objecting to or refusing to participate in illegal activity. And it doesn't make any sense to protect a private employee from that and not a public employee. At our conference, this was the one area where one of our speakers said perhaps you'd get the Court of Appeals to move. That if I, as a public employee, refuse to participate in in a illegal activity and was retaliated against and was not otherwise protected, that the Court of Appeals would not be able to stomach not protecting me in that situation under any employment will. But although I think Mr. Roughton has a case for saying that the Court of Appeals is so adamant about this that they're going to look for anything further is going to be coming from the legislature. That, I think, is an area where there surely should be some movement of equating public employees with private employees. Yes, sir.
I'm going to ask you for an opinion. Is it the statute itself, or is it some other reason that causes the Court of Appeals to be strict constructionalists in this particular instance and not in others?
The statute itself here, clearly. The statute itself, there's nothing in the in Section 75 of the Civil Service Law that mentions the language object to or refuse to participate.
You don't think it's something else other than the language of the statute itself that causes them this discomfort in liberally construing this statute when they liberally construe others?
Not in this area, not in the particular area I just referred to, right? Now, there is there's been referred to here the requirement of reporting, which is really in effect an exhaustion of administrative remedies type of thing in both statutes. And I think that the question really, if there is not equating the two, because they are to a large extent equated, the question is really whether you want to leave those stand. The FARA Commission suggests that really puts a very chilling effect on whistleblowing, and it really dries up a lot of whistleblowing. This requirement you report to the agency that may be, in fact, the person you have to report to either may be the one or may know the one that is doing the illegal activity. And I think that, however, is a tough call. Mr. Bress, when he was speaking at our conference, defended this, at least in the public sector statute, as being one which is really for good government. That you want people to report wrongdoing to their superiors, so the superiors will have a chance to correct it. That's the argument. As again, we're not here to make the commission, and I have not made judgments. I'm just trying to point out that there are arguments on some of these things that are more difficult than on others, at least that I view as being more difficult than others. I would point out, though, that there's an interesting aspect of this. There is an exception to the reporting requirement for public employers that the reporting does not have to be done as a sine qua non if the situation presents an imminent danger to the public health and safety, very much like the language in the private sector bill. And if you take the view of the FARA Commission that this basically dries up reporting in the public sector, then the public sector bill is very much like the private sector bill, because even though the protection is supposed to be against any violation of a rule or regulation, what it really comes down to is that the only one that you can get around reporting to your employee, your supervisor, is one which is for the public safety, which is very much like what the private sector bill does. I don't think that was an intentional attempt, but I think that's the practical effect of it. I would then just like to move quickly to two aspects, one of which has been mentioned before, and that's the publication. Neither statute requires publication. I think that is something that can easily be accomplished with minimal cost, really, that both public sector and private sector employees be aware of whatever protections there are. They should be made aware of them. And then finally, I would just like to speak to the remedies aspect of this. The David and Goliath aspect has been mentioned. I think that's been fully explored, and I think you have pros and cons on that. Bureaucratic, the notion that maybe there is already people in place you can go to, I think it balances out that argument. I would like to say, however, I think that the committee should address an aspect of the employees' remedies that is present in both statutes. Both statutes talk about if a person is retaliated against or is fired or some personnel action is taken because of. the disclosure, et cetera. And the statute does not establish any type of burden of going forward, burden of proof with respect to that. We have, as you know, similar problems in the employment relations law, in the National Labor Relations Act, in civil rights laws, as to what is the reason for an employer taking this particular action. Just take a simple case. The employee blows the whistle. The employer fires the employee. The employee says, I was fired on account of blowing the whistle. The employer says, no, you were fired because you've been late 20 times in the last month. What's the burden? Who has the burden of going forward? I asked before I came down, we have not fully researched this. I was speaking to Mr. Outen before I came down, and he indicates to me he does not know of any particular developed law in the courts in New York. I do know that there are some cases, and I think there's one on the Supreme Court of the United States, that takes the position that what the burden should be on the employee first, just to come forward to show that the activity of whistleblowing was a motivating factor, that would shift the burden to the employer to show that it was not the reason for the dismissal. And in the hypothetical I gave, basically if the employee showed that he blew the whistle or she blew the whistle, and then the next day was fired with the employer knowing about the blowing of the whistle, that basically would shift the burden over to the employer to come forward and show that the reason that the employee was fired was not for that, but because they were 20 days late, and for example, 20 days late out of the last month, and if the employee could show, for example, that it was substantial absenteeism for other employees that were not fired, that would be much more helpful to the employee's case. The point is, I think that the statute should have some address this question and should not leave it up there, because to a large extent, Mr. Outen said, of course, we don't have those problems yet because we can't even get into court because we get a motion to dismiss. But if the legislative is thinking of in effect opening up the courts to more of these things, then they should, I think, address this problem as well. We'd be pleased to answer any questions within the parameters of, again, being the staff and not policymakers on the commission. I might say that we would hope to have a report on this this year, and we would be happy to work with this committee in any respect.
You don't have any legislative recommendations at present that
the commission has not formally made that. Our process is the staff, in effect, makes recommendations to the commission. We have been, this frankly has been, Rosemary has been in charge of this, and she's been working day in and day out on reform of the conservatorship laws, which is a high priority for the commission this year. But I think that bill is just about ready, and she will be going back to work on this one. I think we should be in close proximity to a report on this, and we will certainly supply it to this committee.
Will you be taking a position on the question that you touched tangentially, and that is that we really should have one bill covering both sections? Will you be taking a position on the question of should there be one bill rather than two separate bills?
Usually, that is a position that the commission faces up to. I think so. I think the answer would probably be yes. I don't know what the resolution of that would be, but usually that's a question that the commission considers very important. So I think the commission probably will be taking a position on that.
But it may be yes or no.
That's right. Exactly. May I just say one thing? In my real life, I'm a tax professor at SUNY Buffalo, and I couldn't help but say that if you're going to get into punitive damages, or any type of specification,
I thought you were going to recommend some taxes for us.
That's right. You should think about clarifying the question, at least for state income tax purposes, as whether the compensation in that type of situation should be considered income. It's an area that is in a complete mess at the federal level, and I know you can't do anything about that, but you can do something about at least getting into the question of taxability of these damages, especially punitive damages.
All right, I've just been advised that Mr. Alton's opinion of the Court of Appeals is not similar to mine.
It's an F+.
Well, no, I think that I've been informed that his case did not get to the Court of Appeals.
I wasn't sure that it had, and I didn't want to speak one way or the other.
Well, let me ask you this. Historically, from a historical perspective, has the Commission favored an omnibus bill or favored separate bills?
Well, I tell you, we got into this because of it was part of, we really broke down a larger study on employment at will, abusive discharge, and we thought that to try to make an impact that we should start with whistleblowing first, because if the issues here are large, the ones in the employment at will doctrine are even more difficult and less manageable. So that I think that that's the best answer I can give to you, is that we do hope to have, we did hope to have legislation on this, but in the specific areas of whistleblowing, and then to use that as a broadening out into this other study.
Not to interfere in the process of your commission, but it's been my experience that those who in the legislative bodies who do not like a concept then take the exceptions to the rule and make them the rule so that they obfuscate the whole issue. In other words, what I'm saying is, if we were to say, look, whistleblowing is wrong, and we're going to set up a set of rules that very clearly apply to every situation, we could draft a very tight, very short piece of legislation. But then we hear the voices, well, what if you have an employee who's a nut and wants to drive this employer crazy with all kinds of proceedings, and then if you buy into that, then you're off to the races.
Right.
So I guess what I'm really trying to raise here is does it not make sense, fitting in, segueing into the other point you raised about burden, should we not clearly establish that there is a right to peaceful enjoyment of employment? And anyone who violates that, then the burden upon the complainant is to establish preliminarily nothing more than the fact that they observed the situation, reported it. That's their prima facie case. And then the burden, that in effect creates a rebuttable presumption that there was a retaliation. And then the burden is upon the employer or the public or private employer to come forth with evidence that that's not the case.
Right. Well,
do you subscribe to that, or would you?
I think I would. I'm not a lawyer, and I'm not a practicing lawyer, so I really can't speak from, the extent to which going another way would really hurt the attempted protection. But it seems to me that at least the cases that have decided this question really go in the direction that you're speaking of, and have attempted to take into account really the relative resources of both the employer and the employee in this particular area, and have said, basically, let's start off with a minimal burden on the employee and then shift it to the employer, fully recognizing that is going to provide for situations in which the employer says, this person got away with murder. He blew the whistle, but that was an after-the-fact notion. Because if there's anything I think that from both of these conferences I came away with, which is that there are a few blacks and whites in this, that you're really dealing with a spectrum of probabilities And that, I think, is probably one of the reasons why the Court of Appeals has been so recalcitrant in the abusive discharge area, because they think that, rightly or wrongly, they think that this is something which the legislature has more resources and is better equipped to, and has more responsibility to make those calls as to the probabilities and where the emphasis should lie. As I said, that's certainly not been the history, and as Mr. Outen has indicated, Ms. Knox earlier, has not been the history of other courts in this
So then you're
nation.
saying that in any legislation that we prepare, we should make clear that the substantive rights are set out and that they are clearly articulated.
Yes, and that the
And not get into the
procedural
question-
burdens, I think, are articulated as well.
And not get into this dialogue of is the Court of Appeals
I agree. Yes,
frozen mentally, or not get into that, but just make it clear the direction that we want.
Right. Yes, absolutely.
And you'll articulate that in your report.
Yes, absolutely.
And the other questions we discussed.
Right. Thank you very much for your attention.
Oh, Doug Gentili? I was getting nervous. Somebody's glasses.
I guess we've heard a lot of legal arguments, and they've been very well presented. Can you hear?
Bring that mic closer to you.
All right.
Both of them, those mics.
Okay.
Right.
Can you hear now?
Yep.
Okay. I guess what I was saying is that there has been a lot of legal arguments presented, and they've been very well done. This is going to be a totally different vein. My name is Doug Gentili, and I was one of several persons who witnessed and fought corrupt practices which took place during the mayoral regime of Edward Koch. Just to go over just briefly what I witnessed, there was blatant favoritism given to politically connected developers on multi-million-dollar construction projects, to the extent that we were told not to enforce certain laws and regulations which were supposed to apply to everyone. These abuses, in my narrow scope alone, ended up costing the taxpayers hundreds of thousands of dollars. The abuses also included prevailing wage violations, blatant disregard for minority and female utilization, fraud, and other such practices. I reported these abuses to the City Department investigation beginning in 1986, with updates several months afterwards. There is no record that DOI ever took any action with regard to these allegations. No findings, no penalties, not even an investigation. In June 1988, as a matter of conscience, I resigned from the mayor's office. I subsequently contacted the local news media about the abuses. Based on corroborating documents, other witnesses, and independent investigations, the news reporters verified my accounts and ran the news stories. This was a time of great anticipation. I naively believed that our democratic society would deem it within its own interest to vigorously pursue credible revelations that justice and our American values had been compromised, and protect those who risk their livelihoods, and even more, to preserve the underpinnings of honest government. I was in for a rude awakening. Now, please bear with me for about 3 minutes. I'm going to discuss some personal experiences, but I think it gives a capsule of what many other whistleblowers have to endure also. Number one, the front license plate is stolen off my car and placed on another vehicle. A flurry of parking tickets are run up against my name. I have the tickets pulled and see a description which doesn't match my car, and streets which I don't recognize. The city says I owe $2,000. After much stress, time, and effort to get this matter resolved, it happens again. And a third time, involving my brother-in-law's car, which the perpetrators apparently thought was mine. So I taped the new license plate to the inside of my windshield. Out of spite, they vandalized the front of my car. Number 2, my family and I received obscene and threatening phone calls over extended period of time. I reported these threats to different federal officials, including the chief of the U.S. Attorney's Public Corruption Unit. 3, I received a nasty letter from the State Department of Taxation for hundreds of dollars allegedly owed for back city and state taxes. There is no record of any justification for this, no audit, no administrative hearing, no court decision, no previous correspondence whatsoever. 4, acting on a tip, I send my resume to the anti-bias unit of the City Human Rights Commission. I receive a letter from an HRC official telling me I will be contacted for an interview. Several weeks go by, I hear nothing, so I call the agency. Another official says all interviews are concluded. No, we won't reconsider. Why wasn't I contacted, I ask. We had no way of getting in touch with you, the official responds, even though the woman down the hall had no trouble contacting me a few weeks earlier. 5, in late 1988, officials of 2 state agencies talked to me about hiring me as a consultant. The discussions are serious enough that in one case I am invited to Albany, and in the other case I am put through a dry run of work before I'm hired. Then the word gets out that I'm a whistleblower. Suddenly these officials don't know me. I get no response in writing or otherwise to these serious discussions which had previously taken place. 6th and final. I'm not going to go into all the horror stories. I know we have time constraints. After Mayor Koch is voted out of office, I send several letters to newly appointed officials of Mayor Dinkins. In the letters, I acknowledge the change of administration and the pledges of honest government made by the new mayor. I state my willingness to return to the city, highlighting my previous experience and good work record in the mayor's office. I receive absolutely no positive responses. Even though by some moral argument I'm entitled to return to at least the same position I had left because of the corruption. And given the fact that I resigned under duress and that the continuing nature of the violations could, by a certain legal standard, defer the 1-year statute of limitations in the whistleblower law, it could be legally argued in some courts as well that I'm entitled to reinstatement and back pay. Now, the city ignored both moral and legal arguments, which... Okay, I mentioned this last point only because I don't want other whistleblowers to have to reinvent the wheel. Basically, an employee who's given a choice between engaging in corruption or resigning and opts for resignation should be deemed by the law forcibly discharged. Similarly, the clock on any statute of limitations should not begin until the ex-employee has reason to believe that he or she will not be forced to return to the previous climate of corruption. And there should also be punitive remedies for whistleblowers for both public and private under such circumstances. I guess the bottom line is only a whistleblower, can perform 1, a valuable public service in fighting corruption, 2, achieve an excellent work record after 12 years in government, 3, stand up for human rights around the world, including providing material support for dissidents trying to overthrow communism in Eastern Europe, and 4, help found the only nonprofit publishing company in the United States to promote talented minority authors, and despite all the above, be accorded the social status of a traitor. Like it or not, I'm a dissident in my own country. Like anyone else, I have shortcomings. The ultimate terror of doing something right and receiving no recognition from society for it is that whatever flaws I have will be exaggerated. I fear that I will not have the right to be human. The ultimate tragedy of this is there are much more egregious horror stories than my own. Whistleblowers who have suffered physical reprisals, whistleblowers who have suffered mental breakdowns because of society's criminal neglect. And where do such victims have to turn? You tell me. It seems to me that anyone with even an ounce of decency realizes that the current whistleblower law must be strengthened in different ways. But this is only the beginning. There must be a societal recognition that names such as Karen Silkwood, Frank Serpico, Nidhi Padilla, and Michael Dowd should be related to a certain 4-letter word, H-E-R-O, hero. That any one whistleblower would suffer economic hardships that wouldn't have happened absent the anti-corruption activities is a black mark against every elected official. Whistleblowers and Vietnam vets are birds of a feather, men and women who have served their country in good faith but have been punished for their efforts, betrayed by their own government. For whistleblowers, it is like the civil rights movement before Dr. Martin Luther King Jr., and like other victims of the mean-spiritedness which has unfortunately accompanied America's greatness, we're not going to put up with it any longer. The ultimate danger of this victim-bashing trend is the demise of democracy itself, because if citizens see that those who constitute the glue to civilized society are punished instead of rewarded for reaffirming that civilization, what incentive will our citizens have to respect any authority? Do we really want citizens to question the very legitimacy of government? Finally, I just want to mention that I think this trend has already begun. The gulf between the average American and powerful institutions continues to widen. The demographics of trust erosion are clear. President Eisenhower once warned us about the military-industrial complex. Equally as dangerous is the bureaucrat-financier complex, the well-chronicled marriage between moneyed interest and powerful government officials. In response to this genuine threat to our democracy, let us all take a few small steps on the compelling journey on the other direction. Thank you, and if you have any questions, I'll answer them.
I don't want to take your time, and we're running late, but you've indicated that there was some acts of misconduct that you observed and you reported.
Right.
Okay.
Right.
Not now, because we're running late, but I would be very interested in receiving specification to those charges that you made in writing.
Okay.
If you could mail it to me, I'd appreciate it.
Okay, sure. Fine.
What was the conduct that you observed? Who did you report it to? And what happened to that?
Okay, fine.
Okay.
Thank you. Anybody else?
Names, dates, and places.
Thank you, sir. Next witness, John Shannon, former GE nuclear engineer.
Good morning. Thank you for inviting my testimony today. I received a call last week from Carol Gerstel, who asked me to testify this morning relative to my situation at the General Electric Company. Essentially, I'm going to give the same testimony I gave to the Congress of the United States in November of 1989. Relative to whistleblower legislation on the federal level. My name is Jack Shannon. I'm a retired Marine Corps Reserve officer and a former General Electric Company nuclear physicist, employed at the Knowles Atomic Power Laboratory for over 30 years. This laboratory is located in a heavily populated area approximately 25 miles north of Albany. During an inspection of one of the sites that contains 3 operating nuclear reactors, I discovered dozens of health and safety problems. For example, employees had been listed as having been monitored for asbestos exposure when they had not. Records indicating that asbestos workers had been supplied with air and air purifying respirators when they had not. Indications that asbestos exposure monitoring results had been entered in medical records when they had not. Fire pump tests which had not been performed for 3 years. Fire protection water systems that had not been maintained, making it impossible to fight a fire around the nuclear reactors if the need arose. Failure to properly maintain fire hoses on a site with 3 operating nuclear power plants, none of which contained emergency core cooling systems. A 3 Mile Island type accident would have been impossible to contain. Unlabeled waste drums that could contain anything, including radioactive materials or PCBs. Additionally, a fellow worker discovered that employees had been exposed to potentially hazardous and certainly reportable levels of internal radiation. A laboratory parking lot was paved with radioactive soil 20 years ago, and employees were never told. A former plutonium reprocessing plant located in the middle of downtown Schenectady had been sold by the United States government to a food wholesaler named Byrite Foods in 1955. The result of all the reporting of these findings is, 1, I was dismissed as manager of health and safety. 2, my coworker was summarily fired. The Department of Energy did nothing about the warehouse except perform a self-serving survey, which is at odds with an independent survey which found contamination 7 times higher than required state standards. 4, the Department of Energy bought the contaminated lot from the General Electric Company for $1 and only began cleanup thereafter massive media exposure. The Department of Energy continues to tell the union representatives that no evidence exists that employees are in danger of asbestos exposure, when the facts are that it will cost $100 million to remove up to 4.5 miles of asbestos that has been a known problem for years. As a result of my findings, the laboratory general manager, Naval Reactors, and the Department of Energy have combined to force me from the company and have my security clearance revoked. This is evidenced by the following. A dishonest retaliatory audit against the nuclear safety component of my program was published 16 days after I published my findings. Using the dishonest audit as a pretext, I was summarily removed from my position. Within several months, I was again demoted and removed from a position in which I am still considered the laboratory expert. Untrue testimony was provided to the Office of Personnel Management in an effort to have my security clearance terminated. The loss of a security clearance is the same as the loss of a career. Since requesting the DOE Inspector General to investigate my allegations of March of 1988, the retaliation intensified. 3 unsatisfactory performance appraisals were issued against me in May of 1988, October of 1988, and May of 1989. I was denied opportunities to bid on open positions. I was threatened with loss of salary. I was denied a fair hearing by the local field office of my harassment complaints. This denial was appealed, however. I was denied an investigation by the Office of Personnel Management. This denial is also being appealed. And I was requested by management to see a psychologist. Eventually, I was placed on disability by my personal physician. A fair assessment of all of the evidence will clearly show that GE management and Department of Energy field office management attempted to cover up a $100 million asbestos mess at the laboratory. The asbestos problems have been an ongoing union management controversy for many years, and my audit validated the union's position. In conclusions, others who have raised safety concerns have also been abused. Frank Bordell was fired 20 days after contacting the Department of Energy Inspector General about internal radiation overexposures. He had worked in the Knowles Atomic Power Laboratory for 20 years. He is still fighting for vindication. To our dismay, we have discovered that there is no formal mechanism in place to protect whistleblowers. Others with safety information observe what has happened to Bordell and me and have remained silent. The laboratory clearly wants it that way. On September 15, 1988, Knowles management issued a gag order to all employees warning us to not even comment on laboratory activities. The penalty for committing the truth is termination, a $100,000 fine, and life in prison. By the terms of that gag order, I suppose I'm at risk for testifying before this committee. Legislation is obviously needed to correct this outrageous situation. Thank you, and I will be happy to answer any questions. And I'm thrilled that this testimony is taking place today.
I understand you started a lawsuit. Have you?
That is a very iffy situation right now. Mr. Bordell, the individual I referred to in my testimony, after nearly 3 years, was finally granted an opportunity to have his case heard in state court.
Right.
by virtue of the fact that federal preemption did not apply in his case. Whether or not federal preemption will apply in my case is still a rather iffy question, because I was not fired immediately. I was demoted twice, and eventually I was driven out of there for medical reasons.
Oh, you were driven, I see, okay.
Yeah.
So the argument was you don't fall within the purview of the statute?
Perhaps and perhaps not. Clearly what I reported was and still is of imminent danger to the personnel who live in and around Saratoga County, probably within a 20-mile radius of Saratoga County.
How long had you worked for GE?
Approximately 30 years.
30 years?
Yes, sir.
And how many complaints or how many times had management ever questioned your work prior to that?
Never. I had an excellent record at the laboratory. I was eventually promoted to a subsection manager in 1982. Prior to that, I was assigned the lead engineer job for the design of the most widely used nuclear reactor in the United States fleet today. And I was assigned responsibility for nuclear safety for the laboratory from 1972, I believe, until 1982, at which time I was promoted to manager of safety for the entire laboratory, including Windsor site, which is in Connecticut, Kesselring site, which is located outside of Saratoga, and the Niskayuna site over here.
I didn't quite get from your testimony. You read through it, but I didn't quite understand exactly what action you took when all of these things you saw occurred. For example, when you saw the asbestos problem, what action did you take when you
I wrote a report. The report was published on November 26th, 1985, and it was about a 20-page report identifying all of the asbestos issues, as well as a variety of other health and safety problems, including firefighting problems and fire alarm problems. The inspection just went on and on and on.
And was there any recognition ever by management that any asbestos problem existed?
Yes,
or that
sir.
it would be corrected?
Yes, sir. I have a direct quote, which I hope I can find. Several months after I conducted my inspection and reported all of these issues, particularly the issue related to the asbestos problem.
Oh, by the way, who did you report this to?
Who did I report it to?
Yeah.
Oh, I reported it to the general manager of the laboratory, United States government, both at the local field office in Schenectady and headquarters, the Department of Energy, and the United States Inspector General's office.
Is that at the same time you did this, or?
Essentially the same time, yeah. The report was issued on a single day, and within a matter of days, they all received the same inspection report.
And was that pursuant to any federal regulation or authority that requires this procedure when you notice?
It's been classified as a protected activity by the United States government, yes, sir.
Because these are different procedures than one, I assume, who was working for the state of New York and wasn't regulated by the federal government would have to follow in an effort to make this complaint.
Well, the indications presently seem to be that health and safety activities, even at federal facilities, are not regulated by the federal government. That we are still citizens of the state of New York and entirely entitled to the protection under that law. I'd just like to read a quote for you, if I may. Several months after I conducted my inspection, the Department of Energy, at the request of a number of sailors stationed at the site, conducted an asbestos audit themselves, because the sailors were being forced to work in a very dangerous asbestos environment. And the quote from their own inspection report stated that management attention to asbestos work requirements simply did not exist, unquote.
Say that again, I'm sorry.
Management attention to asbestos work requirements simply did not exist. That's a direct quote from the Department of Energy document. Now, we have to remember that there are approximately 2,500 citizens of the state of New York who are employed by this laboratory. About, I would say, 1,500 in Niskayuna, which is just outside of Schenectady, and probably 700 or 800 in Saratoga County, West Milton, which is about 10 miles west of the city of Saratoga. None of these people are going to step forward with health and safety violations after they've seen what happened to Jack Shannon. The Department of Energy is a disaster. There's no question about that. We've all read what the Department of Energy has done. Right now, the United States taxpayer is looking at something like $250 to $500 billion in cleanup based on the Department of Energy's mismanagement of the energy program. And people are not allowed to step forward and say anything. If it were not for whistleblowers, the Department of Energy would not have volunteered one piece of information relative to the program. The only information that Americans have gotten about the Department of Energy has come from people like me. And every site in the United States in which whistleblowers have stepped forward, the whistleblowers have been slaughtered. At the Hanford Reservation, Rocky Flats Reservation, Savannah Rivers Reservation, Fernald Reservation, the Knowles Atomic Power Laboratory. There's not a single site in the United States where whistleblowers have stepped forward and have not been slaughtered. I am not unique. Believe me, I'm not unique.
Forgive me if I belabor this, but I just want to get clear in my own mind about the procedure that you followed, because I don't.
All right.
The procedure that you followed, was that a procedure that you devised, or something that was mandated by your employer for you to follow when you discovered some malfunction?
As part of my job responsibility, I was required to perform this inspection on an annual basis. I published my report on November 26, 1985.
And were you required to publish it and distribute it to all of the different agencies that you mentioned?
There was no requirement to distribute it to government agencies, but as a matter of courtesy, we always did that.
Okay.
So within 12 days, they nailed me with a falsified audit against a portion of my responsibilities at the laboratory, and there's never been any question that that document was falsified. I've heard the Inspector General talked about it at this meeting a few speakers ago. I found the Inspector General, at least on a federal level, to be part of the problem, and not part of the solution.
Someone once said when they find an old hack, that's where they throw them.
You said that, sir, not me. There are states in the Union that have very good whistleblower laws, I understand. The state of Illinois, I understand, has a very good whistleblower legislation. State of New York, it's my understanding, is probably one of the poorest in the state, or the nation. If you really want people to start stepping forward and telling the people of the state of New York where the problems are in environmental issues and health and safety issues, personal employee problems, mismanagement of government funds, either federal or state, you're going to have a whistleblower legislation. People will not step forward and be slaughtered the way I was slaughtered. It just won't happen. Frank Bordell started his litigation, I think, in April of 1988, and it wasn't until November of 1990 that the New York State Second Court of Appeals ruled that he could have his case heard in New York State courts. Now, this is not a David and Goliath situation, ladies and gentlemen. This is 3 Goliaths against 1 David without a slingshot or stones. This is ridiculous. In Mr. Bordell's case, one lawyer quoted him a figure of $50,000 to bring his case to court. Now, here's a guy who was fired after he reported radiation problems, so he doesn't have a job. He doesn't really know what to do because the legislature is so unclear. You really have to be a Philadelphia lawyer to figure the thing out anyhow. And he walks in a lawyer's office and gets told, well, it's going to cost you about $50,000. Now, that's obscene. That really is obscene. And he did a fantastic favor for his fellow employees as well as the citizens of the state of New York. And what's happened to Frank Bordell? He's living in California now. We cannot fight these battles without help from the state legislature. It's just impossible to do it. There's the legal part, there's the legal cost, there's this time involved. We're under pressure without jobs. I mean, fortunately, I was placed on disability by my personal physician so I can live. I mean, I can't live very well, but at least I can eat. I served my country, I served this state, and I served the government. And this is ridiculous. It really is ridiculous. And then you turn to some place in the state of New York to try to get a hearing. Nothing happens. We are presently sitting 25 miles from the single most dangerous nuclear facility in the United States today, and nothing's being done about it. Not a thing. We have a landfill in Niskayuna, which is maybe 15 or 10 miles away from here, something like that, which may very well be the worst landfill in the entire state of New York, and the state of New York is powerless to take action against that landfill. Powerless. We have verbal testimony that there is radioactive material buried in that landfill, there is hazardous waste buried in that landfill, you name it, it's buried in that landfill, and we can't do anything about it.
Why not?
Because the federal government says, although this is state land, it's inside of a federal reservation, which it is not, by the way, and you people do not have authority over this. Your state agencies know about this. The Environmental Protection Agency of the state of New York knows about this. The New York State Department of Environmental Conservation knows about this facility. Nothing can be done. I personally have 2 documents written by General Electric management relative to the contents of that landfill, which are contradictory. One was written in 1986 and the other was written in 1988. The 1986 report says the landfill's a disaster, and in 1988 it says it's not a problem. The only difference is in 1988, Jack Shannon, Frank Bordell, and a couple of other people stood up to be counted. And a lot of this information started to get out to the public. They won't even put a shovel to that landfill to see if there's anything wrong with it. I know why they won't put a shovel to that landfill. You know, it's,
said it all.
Thank you very much for excellent testimony.
Thank you very much for inviting me. I really appreciate it. Thank you.
Next witness, Ron Dunn, Gleason, Dunn, Walsh, and O'Shea.
Yeah.
Good afternoon to you all. Thank you for having me here. I very much appreciate the opportunity to speak today. I am very privileged to be coming here as an advocate on behalf of whistleblowers. I have had the privilege of representing several whistleblowers whose only recourse is the statute that you are examining today. Among others, I've worked very closely with Mr. Shannon and Mr. Bordell, who you've heard a great deal of testimony about. I find these two gentlemen to be remarkable in that they have been asked to make the ultimate sacrifice, the ultimate economic sacrifice. They have put their job at risk. They are here, and I am here, asking you to make some modest modifications in an otherwise good bill in order to give people like Mr. Shannon and Mr. Bordell and others an opportunity to work to bring to fruition the original intent that the legislature had in passing this legislation. As I say, I'm here on behalf of many whistleblowers. Some of them, the only recourse they have is this statute. Others have had the opportunity to bring cases under statutes which track the New York statute, but which are not the same as the New York statute, and in some respects they're better. And I come to you asking you to make modifications using that as a guide. I am a practitioner. My comments are based on my experience in the court systems with the tools that you have given me, one of which is this statute and the others are other federal statutes.
Did you happen to be here, by the way, for Mr. Outen's testimony?
I'm sorry?
Were you here when Mr. Outen testified by any chance?
No, I was not.
Okay.
And the simple reason for that is I have to labor.
That's all right.
My comments really raise 3 points. The first is I would ask for at least, if you can do nothing more, I ask that you modify the private sector whistleblower statute, Section 740, to mirror that portion of Section 75B of the Civil Service Law, which suggests that a worker is protected if that worker has a reasonable belief, and I'm going to deal with this more in greater detail. My second area that I would ask that we have modifications on is to provide a funding device to permit somebody to live, to eat, and to basically hire a lawyer to fight their employer if they have been forced to make the ultimate sacrifice of losing their job in an effort to come forward and work for themselves and the safety of everyone. And the last thing is that I think that we need, I'm sorry?
How would you do that? What do you recommend?
I have in-depth recommendations, and I can cover those now or in my text.
However you want.
Okay. The last thing and the third item that I will cover in greater detail will be, I think that you have to change the remedies that the whistleblowers get at the end. I'm not asking for a lot, I'm asking for a little. And that will have the salutary effect of rewarding people who've been asked to make the ultimate sacrifice and encouraging other lawyers to take on these kinds of cases. I can tell you, because I've had many whistleblowers come to my door, I can tell you that the number of people in this state who are willing to take on these kinds of cases against these kinds of Goliaths is very small. And we need to do something to encourage more people to take care of these things. Let me first deal with my first point, and that was to amend the statute to track the civil service law provision calling for a reasonable belief. At present, Section 740 could be read to suggest that somebody who does blow the whistle does so at their peril, that they are absolutely correct and right on the law. We're not dealing with lawyers out there. Even if we were dealing with lawyers in the workplace, it is not easy to imagine that we are living in a very technical society. Our technology is rapidly outstripping the regulations that we have in place to regulate that technology. It is very, very common that we are using regulations to regulate new areas of technology that were simply never contemplated to regulate this technology. So a whistleblower who comes in and says that they believe that a particular practice violates either a law or a regulation is doing so by applying a whole set of regulations or statutes that were put in place to serve a totally different purpose, some other purpose. It is asking too much to ask that person to know for certain how the courts and how someone will look at this with 20/20 hindsight much later on, whether or not this actually violates the original express intent of the legislation or the regulations. I believe that when ultimately put to the test, Section 740 will be read by the courts as suggesting that the standard is not that the employee had to be right about whether the particular practice violated the law, rule, or regulation, but only that a reasonable person sitting in the shoes that they were sitting in at that time had a reasonable good faith belief that there was a particular violation of the law, rule, or regulation. That is my belief of what the law will ultimately hold if you don't amend the statute. But I suggest to you that merely by tracking 740 and tracking it with the amendments to Section 75B, adding on that language which modifies the statute to suggest that if the employee had a reasonable belief, good faith belief, that will be enough. That will do wonders for whistleblowers, and it requires no additional expenditure by anyone, and it's a very modest modification. It is totally in keeping with many, many, many federal and state whistleblower statutes. My second area that I want to cover, and it's something that Chairman Barbero, you mentioned earlier, you wanted some further elucidation on, was how to provide a funding device for employees during the course of their litigation. I would ask you to consider adopting at least some of the provisions of a federal statute known as the Surface Transportation Assistance Act. It's found in the appendix to 49 USCA. It's a very difficult statute to find. Even now that you have that statute, I defy you to find it. It's very difficult to find.
Okay, would you send us a copy?
I would be glad to. I would be glad to. What you'll find is this statute was enacted to assist the people in the transportation industry. I don't have to tell you how dangerous a 18-wheel tractor trailer can be if it doesn't have brakes or if the steering doesn't work or things of that nature. It would make your hair stand on end if I was to share with you some of the stories that the truck drivers tell me about being forced to go out on the road with trucks that simply have no brakes or bad brakes or no steering or bad steering. The stories are horrendous. We have had the privilege of representing whistleblowers in the transportation industry who have brought proceedings under this relatively new federal statute, as I say, the Surface Transportation Act. Now, what this does, the mechanism which I suggest that we adopt here, or at least something like it, is it provides that the Federal Department of Labor act as an investigator. They investigate a claim that a particular driver has, and the statute basically mirrors the New York statute in that if the driver can refuse to take a truck out on the road if he believes, he has a reasonable belief, that taking the truck out would violate some state or federal law, rule, or regulation. There's also a similar statute which says that, a tracking statute which says that the driver can refuse to take a truck out on the road if the driver has a reasonable belief that doing so would endanger the public health and safety or his own health and safety because something about the truck is unsafe. The motive for the statute is obvious. It's to protect everybody on the road. What's unique about the federal statute is they have the Department of Labor investigate the claim. If the Department of Labor finds that there is some probable cause, that there is a good faith claim here, and that there's a basis for the claim, the Department of Labor has the power and the authority to direct the reinstatement of the driver pending a final hearing on the merits. That provides the number one vehicle, in my estimation, that will go a long way to curing a lot of things. Because what it does is it gives sustenance to the whistleblower while they're trying to fight for their job back. It allows them to put bread on their table. It also allows them to hire a lawyer in order to get the job done on the statute. I suggest two alternative ways that we could do that within the methodology that we have in New York State, how we could just lay it on. One would be more than modest, and that would be to set up some kind of special counsel or designate a particular agency that will investigate these claims to make an initial probable cause determination. That's going to involve money. There's no doubt about that. Another way to do it that would involve no money, would be to provide a specific statutory authorization that would permit the private lawyer to go to court and require a preliminary hearing on whether or not there is a good faith basis for the claim. Under our civil practice law and rules, there is a provision permitting injunctions in aid of a particular lawsuit where you can maintain the status quo. Under many cases and lots of procedural rulings over the years, in order to get an injunction, you have to show two things. One is you have to show that you have a reasonable likelihood of success on the merits of your case. And I'm not suggesting that we tinker with that in any regard. The other thing you have to show in order to get an injunction is that if you don't get the injunction, you are going to be irreparably harmed. Now, through a long series of cases in New York State, the courts have said over and over and over again, if money will make you whole, you're not irreparably harmed. And they have said specifically, if your job is in the balance and you're being put out of work, money will make you whole. So you can't get an injunction, except for in very rare circumstances. You cannot get an injunction under the existing civil practice law and rules in New York in order to aid the jurisdiction of the court. You can't get it because you can never fit, or you can never show that second wing of the test, and that is that you've been irreparably harmed. What I would suggest, which would be a very modest modification in the statute at no additional cost to the taxpayers, would be to permit obtaining an injunction if the particular employee could show reasonable likelihood of success and that they've been put out of work. That would require the status quo pending a final determination on the merits. That would be my modest proposal for providing a way and a methodology to give some funding device to the whistleblowers that are out there.
Can I ask you a question at this point? It doesn't provide any money for counsel fees, however.
The statute provides money for counsel fees, and I'm going to get to that next.
Okay, then let's stay with this one. Would we be faced by a federal preemption obstacle if the state came in and directed an employer to reinstate a worker?
Federal preemption under which grounds?
I'm sorry?
Under which ground? I can tell you that Mr. Shannon briefly talked about the Bordell case, which was just decided by the Third Department. That's my case. Okay. And the federal preemption argument in Bordell is of great interest to this locality because we have a federal installation here, and there is a real federal preemption question. There's not that many federal installations in New York State. So the federal preemption case in Bordell is very important for Frank's case. It's very important for people like Mr. Shannon. But overall, federal preemption on the narrow grounds raised in Bordell is not a big issue.
I'm not sure where I'm going with this, but if there's a collective bargaining agreement and the state comes in, the state cannot come in and interfere. They're preempted.
Well, it depends on if the state statute is giving a remedy that is not available under the collective bargaining agreement. There's many cases which hold that it's not preempted.
All right, and so if you don't have a collective bargaining agreement, then you don't have that.
You don't have that issue. If you do have a collective bargaining agreement, then the employee has a choice of remedies. They can either go under the collective bargaining agreement,
right?
And that's typically designed to be fast, not always fair, but very fast. Or they can go.
You're looking at 2 or 3 years.
Pardon?
You're looking at 2 or 3 years at best.
Under the collective bargaining agreement?
In most
Sometimes.
many cases.
Sometimes. I can tell you that in the particular transportation case that I'm involved in now, the employee, kicking and screaming, was forced to go through the collective bargaining agreement process. The particular hearing officer who was appointed in that case heard a very, 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 very complicated case. The whole hearing took no more than an hour. The particular person's representative never met my client until about 35, 40 minutes before the hearing was commenced, and we had an extremely complicated question about whether or not this person had a good faith basis to refuse to take a truck out on the road. Well, it shouldn't surprise anyone that in rapid order, the company had affirmed its power to dismiss this person unilaterally, and it was all done on a procedural nicety. It had nothing to do with the merits of whether the guy was blowing the whistle. It is entirely possible that our federal claim under the federal whistleblower statute is going to be impacted by this Star Chamber proceeding. So we do have a federal preemption question, but we don't necessarily have to legislate that question away. There are ways to get around federal preemption, and labor lawyers such as myself deal with this issue every single day. And if you give us the toolbox, we'll get around the federal preemption. You just give us a state remedy that's designed to remedy public health and safety issues, we'll get around federal preemption.
I'd like to try to do it when we write the statute.
Yeah.
I'm not sure that it's possible, but good luck. You either preempt it or you're not. As you know, Section 740.
With asbestos, we can do it. With asbestos, we say we're not federally preempted by OSHA if the area that we're dealing with is open to the public and the public health and safety is involved, as well as the workers, so that we're not federally preempted. So that's how we do it.
I heartily endorse that, because it gives us all two remedies, which, if for some reason you're inclined to go with the collective bargaining agreement remedy, all the more power to you.
All right, so what you're saying is that the whistleblower who has collective bargaining protection, that's their protection.
That's some of their protection.
Some of their protection. Where there is no collective bargaining agreement, there's no preemption.
There's no preemption article. Okay. Even if there is a collective bargaining agreement, you can claim, and there is some case authority for this, that a state whistleblower claim does provide an alternative remedy, so that you can take it, because it's giving you things that you don't get under the collective bargaining agreement. It gives you remedies that you don't get. So there is a way to avoid that preemption difficulty.
Okay.
My last point is to modify the remedies that are available to an employee. I was here when Mr. Shannon testified, and I heard his comment about the $50,000 quotation from a lawyer. I can tell you that...
You don't charge that much?
Well, I can tell you that we've run up that kind of bill. But you can't ask a client who's out of work and has no funding device to pay you the amount of money that you could ask if you were representing the employer. You just don't have those kind of resources. The employee doesn't have those kinds of resources. And so what all people who decide to take this side of the fence have to do if they want to do this kind of work is you have to come to grips with taking cases on a contingency where you will take be satisfied with either a percentage of the ultimate recovery or settlement, or the attorney's fees which are awarded, whichever is greater, or some variation of that theme. The statute already provides for reasonable attorney's fees, and there's tons of cases which tell you how to make that application, and there's also many cases which say under what circumstances you get attorney's fees and what circumstances you don't. And we can adapt those other cases arising under other statutes to remedy that particular part of the problem. However, back pay, standing by itself, is not enough to compensate somebody who's been to hell and back because they've had ripped from underneath them their sustenance. In our society, maybe it's a bad thing, but in our society, people get their self-worth and their self-image from their job. You know, next to your family, there's very little that's as important to you as your work and your career and your job. So when the employer takes that away from you and strips it away, there is substantial emotional harm that goes with that. You go through a roller coaster, and you know, it puts a lot of stress on your family, it puts a lot of stress on your marriage, it puts a lot of stress on everything to do with your life, and it dramatically changes you in many respects. Saying that all you get if you go back to work is what you would have gotten if they hadn't fired you in the first place does not justly compensate an employee. It doesn't put them in the same position that they would have been in, because as I say, they've been to hell and back. What I would propose is that the statute be amended to provide for either compensatory relief in the form of tort damages, in order where you would have to come in and prove that the particular employee had emotional problems or was put through the ringer or was put through a roller coaster, and you get the damages that you would be entitled to. There's no secret or mystery. We wouldn't have to invent the wheel as to how you prove those. Those are being proved every single day. If we just walk across the street to Albany County Supreme Court, we're going to see that particular case going in today and every other day. I suggest that we add that to the array of remedies that are given and awarded in an appropriate case. I also suggest that we add to the pie exemplary damages or punitive damages. Those kinds of awards would only have to be awarded in a truly egregious case where you've got outrageous conduct on the part of the employer. I'm not here to tell you, and I'm not so Pollyannish to suggest, that all of these whistleblower cases are just, you know, totally one-sided. There is some gray area in some of these whistleblower cases. But I am here to tell you that in at least some of these cases, there is no gray. It is completely black, and it is completely white. That the conduct of the employer was completely outrageous and at every step of the way. With a motivated employer, there is almost unlimited resources on the other side. I have been in the courtroom where I have seen 4 lawyers show up on the other side, complete with charts and diagrams and flow charts and flow diagrams. I gotta tell you, I have my own opinion as to whether or not that was valuable or good for their case, but I can tell you this, it sure showed me, and it was a very powerful message to me, of the resources that were being arrayed against my client. And what I'm suggesting to you is that if you award exemplary damages in an appropriate case, particularly egregious conduct, that will provide further incentive for other lawyers to take on these kinds of cases, because there's not a lot of us out there. It will also provide some reasonable and just compensation for the people who go through hell in order to blow the whistle and make the ultimate economic sacrifice.
Thank you very much. Our next witness, we're proud to have the Controller of the City of New York, the Honorable Elizabeth Holtzman. Good afternoon.
Thank you very much, Assemblymember Lenthal and Assemblymember Barbaro, and I'd like to introduce Dixie Hathaway, who's my legislative counsel, who's sitting here with me. I want to compliment the standing committees on governmental employees and labor for holding these hearings on whistleblower legislation, to express my appreciation to the chairs for demonstrating their leadership on this very important issue, and I also, of course, appreciate the opportunity to testify about my proposed whistleblower legislation. Today, I offer you my proposal for a comprehensive revision of the state civil service laws on whistleblowers. As I will discuss, this proposal, if adopted, would place New York in the forefront in sounding the call against waste, fraud, corruption, and mismanagement in government. This groundbreaking initiative is necessary on one hand to pull New York out of a whistleblowing rut, but it is also bold in moving New York to a creative, constructive, and supportive treatment of whistleblowers. Patterned after federal legislation, this proposal could establish New York State as a model in whistleblower protection for states across the nation. Through the 1970s and 80s, the term whistleblower usefully identified the people who sounded an alarm about corruption, graft, and mismanagement in government. Ernest Fitzgerald was an early example. He was a cost expert at the Pentagon in the 1970s who found a $2 billion cost overrun and told a congressional committee about it. His work may have been hailed by taxpayers and congressional representatives, but it was assailed by his superiors in the White House. To them, he was merely a troublemaker, and court records show that even President Nixon ordered subordinates to get him. Fitzgerald's next assignment was hardly a thank you note. He was ordered to audit bowling alleys in Thailand. But in the 1990s, the term whistleblower may not be tough enough to express the value of employees like Fitzgerald. The term whistleblower doesn't shout forcefully enough about how important these employees are to rooting out government ripoffs. The term whistleblower doesn't yell loudly enough about the courage that it takes to buck a system that appreciates whispers more than whistles. The term whistleblower doesn't have the ring of a Medal of Honor, doesn't even thank the real-life heroics of public servants who put their jobs on the line in the service of ethics and effectiveness in government. Instead of mere whistleblowers, these employees really should be thought of by words that get to their real guts and grit. I think we should borrow from TV lingo and call them wastebusters or fraud fighters or sleaze liquidators or maybe budget avengers. But those inside government who are willing to rip the covers off looming scandals deserve our thanks, our aid, and at the very least, our protection. The serious budgetary needs of New York State, New York City, and other municipalities mean whistleblowers are more important now than ever. Taxpayers always recoiled at waste and corruption in government operations, but given our fiscal situation today, more than before, every dollar needs to do a dollar's worth of work. The coffers of government and hardworking taxpayers cannot afford to be mugged by mismanagement or misdeeds. When encouraged, employees can be the eyes and ears of ethics and efficiency in government. Even the most well-meaning legislator or executive officer cannot monitor the vast complexity of government programs and operations alone. I know from firsthand experience how important the tips of employees can be. When I served as the Brooklyn District Attorney, my office cracked a major case involving bribes to safety inspectors by school bus officials. It all happened because one employee at the Department of Transportation thought more about the safety of kids than the wallets of inspectors. The entire investigation began because of a single whistleblower. As controller of New York City, I was able to expose a terrible situation in which the Human Resources Administration was itself endangering clients and their children on a daily basis by cramming them into a photo ID center, despite huge fire and safety hazards. One employee, upset with the situation, phoned my call-it-off hotline. If HRA now undertakes decentralization, as my office has suggested in response to correcting this problem, the department may not only comply with fire and safety laws, but may ultimately save hundreds of thousands of dollars a year. Unfortunately, as you know, whistleblowers are often made into chumps instead of champs. Recent incidents have made headlines. In one, a city employee was fired after he publicly warned that cutbacks on bridge repairs would create a safety hazard. In another, a Human Resource Administration clerk was suspended after turning in fellow employees who regularly took 2.5-hour lunch breaks. Now, I don't know whether these individuals made justified allegations or not, but I do know that concerned people who speak out with good intentions should be shielded from the acts of reprisal. That's only fair. Sadly, the whistleblowing laws in New York State offer little protection. Their shield is riddled with gaping holes. And if protections offered to employees who speak out are wafer thin, the incentives to take action are completely missing. Employees who discover fraud cannot be blamed for being afraid to report. There are 6 points that illustrate the inadequacy of the current civil service law. The current law robs a whistleblower of anonymity by requiring that the employee first make an attempt to report the act of wrongdoing to someone within the employee's agency. Potential whistleblowers are in this way discouraged from coming forward and making waves. And if an employee's supervisors are the very people involved in the misconduct, the employee might simply be committing career harakiri by making a report. An assurance of anonymity is the first line of defense in preventing retaliation. 2, requiring the report of wrongdoing to be pursued at the agency level means that determinations of impropriety are inconsistent. Each agency applies its own interpretation. Currently, there are no uniform standards for the review of whistleblower allegations or retaliation. 3, under the current law, a public employee who intentionally or inadvertently first provides information to someone outside the agency is not protected at all from retribution. This is a severe all-or-nothing penalty for an employee who may often be completely unaware of this hidden trap. And outside agencies are often appropriate investigators. Certain laws, for example, those relating to child health and welfare, may offer contradictory guidance. And the Fourth Estate role of the media in uncovering governmental corruption and mismanagement has a valuable and undeniable role in keeping the government clean, reaching back to Boss Tweed, the Pentagon Papers, and Watergate. 4, the only protection afforded a whistleblower applies to reports of violations of law. This definition is too narrow. I proposed legislation in 1986 to correct this provision by including misdeeds related to improper governmental action. In the final adoption of this section, however, limiting language was added that undercuts and dilutes the original intention by defining an improper action as one in violation of any federal, state, local law, rule, or regulation. This means that whistleblowers could be trapped if the misdeed they report is not an actual violation of law. The reason I originally sought to expand this definition is simple. Many areas of impropriety, abuse of authority, waste of funds, or mismanagement ought to be curbed, but may not be violations of the law. In fact, the history of this country is rife with instances in which misdeeds are identified first and subject to lawmaking thereafter. The average individual cannot possibly be expected to know in every case whether an action violates a law, rule, or regulation. That's a judgment for which even lawyers must engage in a few all-nighters in the library. Placing this burden on whistleblowers is tantamount to making an employee the informant, attorney, prosecutor, judge, and jury, all before being allowed to utter a single word. 5, additional language under the current law provides protections to whistleblowers only in instances in which the wrongdoer presents a substantial and specific danger to public health and safety. This language is also unnecessarily confining. The standard of public health and safety has not been interpreted specifically under the civil service law, but the same language appears in Section 740 of the labor law relating to whistleblowers in private employment. The opinions under Section 740 show the extreme limitations in using public health and safety as a standard. I'm not going to give you the examples because I think these have been quoted in prior testimony, but I would appreciate the text of my entire testimony being made part of the record. Splitting hairs over the definition of public health and safety is unnecessary. Can we really expect an employee with information about mismanagement to sit with copies of Nader, Machiavelli, McKinney's, and de Tocqueville before reporting a potential ripoff? Placing these kinds of burden on the reporting employee does no good to anyone. 6, a problem arises under the existing law because whistleblowing employees must also bear the burden of defending themselves if they become the subject of retaliation. The only recourse available to them now is a civil suit or an arbitration action against their own agency for which the employee must bear the costs. This is an overbearing extra price to demand from an employee who presumably was only trying to do the right thing. The inadequacies of the current New York whistleblowing laws were cataloged by the New York State Commission on Governmental Integrity, chaired by John D. Furyk, Dean of Fordham Law School. After an extensive review of the laws, the Commission issued its report last spring, calling for better whistleblowing laws. The report noted that, and I quote, public employees continue to have a deeply held fear of reprisals, close quotes, for reporting wrongdoing. Similarly, the New York State Organized Crime Task Force urged the passage of, quote, more expansive whistleblowing legislation, close quotes, in order to deter fraud, waste, and abuse. The saddest part of the law's failure in New York is the damage to public trust. And of course, what is truly lost is this: the opportunity to serve the public better. The legislation that I am proposing would completely revamp New York's whistleblowing laws. Instead of trying to patch up New York's laws on a piecemeal basis, this proposal offers a comprehensive revision of the law. New York could send a strong signal to its employees that the state is serious about integrity in government. And if adopted, this legislation will catapult New York to becoming a model for other states throughout the nation. My proposed legislation is closely patterned after refinements in the federal law that were enacted in 1989. I am proposing a new title to the Civil Service Act that will both remedy the deficiencies in New York existing law and take several bold steps forward. I'd like to highlight the features of this legislation. At the cornerstone of this legislation is the creation of the Office of Special Counsel. Whistleblowers cannot possibly have adequate protection if their only recourse is to go to people tied to the wrongdoing. Employees need an advocate who is not controlled by anyone. The Office of Special Counsel is an independent entity, and it can break through the ties that strap employees. The Office of Special Counsel, in my proposal, has 4 important functions. First, the Special Counsel is empowered to receive and investigate disclosures of improper governmental action, waste, fraud, graft, from employees. This is a vital step in assuring employee anonymity while at the same time establishing a line of inquiry into the improprieties. Employees don't have to feel that they are putting their jobs on the line to act as good citizens. On the other hand, they can feel assured that their reports won't be tossed into the nearest shredder. The Office of Special Counsel will have a specific time frame in which to review disclosures. If an initial determination turns up government impropriety, the agency in question is required to conduct an investigation and report back to the Special Counsel. The second and most important function of the Office of Special Counsel is to investigate allegations of retaliation against employees. The consequences to an employee from retaliation can be severe: demotion, discharge, transfer, wrecked careers, financial distress, and a loss of faith and hope in the system. All of these actions deter other employees who might know of governmental misdeeds as well. The Office of Special Counsel will investigate charges of retaliation against an employee and will do so within a specified time period. Following an investigation and recommendation, the agency accused of retaliation has an opportunity to respond and take corrective action. But the employee's agency does not have final decision-making powers. If the employee's agency fails to take appropriate corrective action to counter prior retaliation, the Special Counsel can initiate a civil service hearing. At this hearing, the Special Counsel serves as an advocate for the employee. A third aspect of the legislation that relates to the function of the Office of Special Counsel is found in language that will establish objective standards of review by which impropriety and retaliation can be measured. The fourth aspect of the Office of Special Counsel, and a key one, is that it will handle the defense of the whistleblower retaliation at no cost to the whistleblower. If the Special Counsel does not seek corrective action, however, the employee would still have the option of pursuing the case independently, and costs would be reimbursed if successful. Other fundamental defects in New York's current law are also addressed by this legislation. One of these is of central importance, and it is this. Under my proposal, whistleblowers will be protected not only when they report misdeeds that amount to violations of the law, but for actions that involve gross mismanagement, gross waste of funds, and abuse of authority, in addition to substantial and specific dangers to public health and safety. By broadening the law, the focus can turn to the real issue at hand, finding out the truth or veracity of the claim, the appropriateness or possible impropriety of the deed, and whether or not the whistleblower was harassed as a result. Time and attention need not be spent trying to determine if the wrongdoing that was reported by the whistleblower was wrong enough or a big enough public problem. Any reports of government wrongdoing deserve whistleblower protection, whether they're big or small. The agencies or people to whom a whistleblower might reveal the wrongdoing are also expanded in my proposal. An employee could report misdeeds not only to a governmental body, but to a law enforcement agency, the Special Counsel, or even the press if the information is not otherwise classified as confidential. 3 other aspects of the legislation I am introducing are exceptional measures that will directly affirm the importance of whistleblowers to the goal of good government. One simple measure will require agencies to post a notice about whistleblower laws. A second provision offers incentives to people who report on government improprieties and waste. A whistleblower could receive up to $2,000 for disclosure, which results in monetary savings to the government. It's an old-fashioned bounty, but if rewards work for television's America's Most Wanted, I think they can also signal that the thieves of taxpayers' money are wanted too. And finally, an amendment I am proposing to the state's finance law will help crush corruption by permitting a private cause of action for graft, fraud, or wrongdoing perpetrated against the state. Either employees or concerned citizens aware of wrongdoing against the state will be able to sue on behalf of the state. This provision mirrors the successful Federal False Claims Act enacted in 1986. Under it, private individuals have an incentive. They can obtain a portion of the recovery for initiating the action. On the federal level, the False Claims Act has resulted in substantial dollar recoveries for the United States government. For example, the Defense Department won an award of $14.3 million against Industrial Tectonics, Inc. in 1989 as a result of a suit brought by a whistleblower. The whistleblower who initiated the suit had worked at the company as a senior pricing specialist and quit after observing practices that he considered to be illegal. And in another case brought by a whistleblower, the Justice Department is seeking recovery of $100 million against Teledyne for allegedly padding bills for aircraft computers by as much as 40%. A similar provision in New York State might offer similar monetary gains and at a time when budget gains are sorely needed. Now is the time to step up the fight against governmental waste and graft. In commenting on the recently enacted federal legislation, one congressional representative said, quote, "By making it safer for whistleblowers to expose costly fraud, waste, and mismanagement, we will be encouraging disclosures that will save billions of dollars," close quotes. At a time that government dollars are at a premium, New York can no longer afford to have whistleblowers' laws made of straw. Insiders who are willing to stand up to corruption and mismanagement shouldn't have to tussle with a host of confusing rules. They shouldn't have to worry that their jobs will be whisked from under their feet. Instead, it's time for government to become its own whistleblower. It's time to sound a trumpet call that announces that employees can and should speak out, that values the opportunity to blast away, and that declares loudly that New York is willing to do more than talk about good government. New York is willing to fight for good government. Again, I thank you for this opportunity to be here before the joint committees and hope that we can work in partnership to pass this vital piece of legislation. Thank you.
Given the state's fiscal constraints and the city's fiscal constraints, I see that you're recommending the Office of Special Counsel. Would you go along with a proposal that put that in another governmental agency so that we wouldn't have to create a special office?
Well, Assemblymember Lenthal, being very mindful of the fiscal concerns, obviously any way that this can be structured that would minimize the price tag would be something I would favor. On the other hand, you'd have to structure it, it would seem to me, in a way that would maintain the independence of the special counsel from the agencies that are being investigated. Otherwise, it seems to me then it will be not fulfilling its purpose at all and a total waste of money. And in the end, it seems to me that the Office of Special Counsel will be a very small investment for a large return of money in the future.
I agree.
No, I'd be interested in seeing copies of your legislation when it's ready.
We have it
Is
with
it
us.
in the packet?
Yes, should be.
It's in the packet? I haven't
don't know if
looked
it's
at
in
the
the packet, but we can give you a copy of, we've drafted proposed legislation, and we'd be happy to give it to you
Yeah.
immediately.
Okay.
Thank you very much. We delayed long enough so that we could hear your testimony. We're happy that you were able to come and join us.
Thank you, and I very much appreciate your courtesy and that of the other members of the committee. Thank you.
Is there anybody else who would like to give testimony before this committee, these committees? Thank you very much. This hearing is adjourned.
You just send it us, and then Debbie can put it in. Okay, so should I? That's great. All right. I won't have it, but thank you. I appreciate it. Oh, and this is also the same thing. This is not.